deeply disturbing news item on finding the poached carcass of an elephant in Simlipal.
Absolutely, sir. Absolutely. We are equally shocked, sir, and equally concerned, sir. Absolutely.
No, but what is the, why is it happening? Because the preventive measures have obviously failed, correct?
Right, sir. True, sir.
We're unable to understand what were the preventive measures that the JTF had suggested and why it did not work, because you were not even informed. I think 7th it happened. That's what the news item says. It happened on 7th itself, and it came to light only some 3-4 days later.
Sir, I'll just quickly, with your permission, sir, narrate the facts in brief.
All right.
So on the 7th, sir, an anonymous phone call was received by the field director, sir, himself. And accordingly, he proceeded to the field on the 8th, sir. Went to the spot, sir, which is in the core area of Simlipal Tiger Reserve, sir. And on that very day, after his own inquiry, the field director's inquiry, sir, it had come to light that poaching indeed happened, sir. And also that the field staff, the 3 of the people who were in charge, range officer, forester, in charge range officer, the forester, as well as the forest guard, were instrumental in hiding the fact as well as destroying the evidence by disposing of the carcass, sir.
My goodness.
So it just came, yes, sir. In fact, sir, I was in the field yesterday, sir. I personally had gone. I had seen, visited all the sites, sir, interacted with all the people, including the watchers. And, sir, it is my firm, I've come to the conclusion, sir, that it has indeed been done. Sir, so very, very reprehensible, as well as we are all in a state of shock, but we have to, so, sir, I'm staying back here only, sir, just to review things in detail, as well as review the entire protection plan, and also to see what went wrong where, because Simlipal being one of our premier protected areas,
yes,
such thing is not, it's absolutely unacceptable.
No, that is one part. The preventive part, you see, the point is that we are always reacting. Even the last hearing, I kept telling this. We are only reacting to a situation all the time.
Sure.
We are not preventing anything from happening. So what are the preventive measures we have to put in place, and how quickly can we put in place? Because this is in a very bad year for elephants in Orissa. It's perhaps one of the worst years.
It has been, sir.
So there's something going wrong terribly. And sure, what about that mapping of the corridor? Do we know how to anticipate elephant movements? The
yes,
other day, we found the 15-year-old elephant female elephant dead, correct? The other day. I mean, I don't know which district it was.
Yes, sir.
Denkanal.
Yeah.
What are the preventive measures, sir? Please give us some idea of what have you planned.
So since last hearing, sir, we have been completely, sir, engaged in talking to various stakeholders, sir, talking to the respective DFOs, asking for very fine-scale planning, sir, to be done. And we are in the process of putting the things in place, sir. I mean, focusing more on preventive measures, sir, actually.
No, Mr. Nair, this is a fully bureaucratic reply you're giving. This is just not enough for, at least for the two of us, to understand what you mean by all this. What is the concrete measure you've actually taken? What are the preventive measures taken?
Sir, as of now, sir, as we have already given, we've tried to explain to the Honorable Court, sir, also. Sir, our elephant tracking system, as of now, we are having the elephant trackers put to specifically track the movement of elephants, sir, in those identified areas which are conflict hotspots. And now, being the crop season, sir, it is being monitored almost on a daily basis, sir, actually. So, admittedly, sir, in my field tours also, I have found out lacunae in certain areas where they are not tracked on a 24/7 basis. We do not have any radio collared elephants in place, which should give us a much clearer idea as to where they move. So we are suggesting all these measures, sir, wherein more science can be brought in.
No. Yeah, you're suggesting something. I'm talking of actually doing things on the ground.
We will, sir, very soon, sir, put it in place, sir. Very soon, sir. When we come back to you on the 18th, sir, we were just in the...
No, that is still a month away. How many more elephants are we going to lose before that?
Sir, we are on it, sir. I completely assure you, sir, we are on it. And all possible steps, sir. In fact...
Sir, we are unable to understand what it is. We're on it, meaning, have you deployed more persons? Do you have what tracking equipment? Do you have cameras? I mean, how are you going to track? What is the population of elephants we're talking? How many persons are going to be deployed for this? We must have some idea.
Sir, we already, sir, in all the vulnerable ranges, sir, and divisions, sir, where elephant conflict is quite endemic actually over a period of time. So we have mapped, already, sir, mapping is already over, sir. We know exactly what are the hotspots.
Okay.
And to the extent possible, sir, and like exact figures, sir, I would not have it straight away, sir, because last 2 days, sir, I've been here only. We have, sir, I mean, as our analysis and our understanding goes, sir, we have sufficient number of elephant trackers deployed. And after hearing also, sir, in few areas like Dhenkanal, for instance, we have increased the numbers also for tracking it, as well as for what are called anti-poaching staffs and elephant trackers and our regular staff. So, sir, admittedly, we have a staff shortage in terms of our regular staff. So that is also, sir, getting addressed because forest guard recruitment is underway, is already over. So, sir, very soon, sir, we will be having, in fact,
Have you involved the villagers along these corridors? How are you sensitizing those villagers?
Sir,
when the elephant comes to trample on their crops or something, they are going to start react irrationally. They will do things that endanger the elephant. This is what is happening. And you have to address the concerns of the villagers, so you have to take them into confidence.
Yes, sir. Yes.
Are your teams, you yourself, are you traveling and talking to the villagers, getting them on board?
Yes.
Whatever measures you're planning, they have to be cooperating with that, correct?
Absolutely, sir. Absolutely. Completely.
So what is happening for that?
They should do what they should not do.
Yeah. What Justice Raman is saying is do's and don'ts. Don't you answer, this is permissible, this is not?
Sir, so may I just take 2 minutes, sir, to explain, sir, regarding this particular people's interface?
Yes.
Sir, so we completely agree to the fact that unless people are taken on board, sir, we will not achieve anything in the longer run, sir.
Correct.
So towards that, sir, there is one flagship scheme, sir, operating right now called Gaj Sathi, wherein it's a scheme wherein we rope in local villages under whose areas there is a lot of elephant depredation. They are trained in not only collecting information but also transmitting it to their villages in time. That they act as kind of an interface between the department as well as the affected villages. Also pass on timely information, sir. Actually, that has been scaled up ever since the last hearing also has taken place. Exact statistics sir, we'll provide as soon as possible, sir.
So give us names of these what Sathis? Gaja Give us the names. Where are they located, and what is the range around which they will operate?
Sure, sir.
And give us the mapping that you've done of the corridor.
Sure, sir. Mapping, sir. We are
let's get down to it. We are not going to wait till 18th January for this. So I have a hearing next week itself.
Sir.
We really, Mr. Nair, I don't know how much we can emphasize this. We want action on the ground now. This has gone on now for long. It seems that we are all helpless bystanders just watching this happen. We just can't afford this.
Definitely, sir. Definitely.
Yes. And this is the moment to seize. You see, these are challenges. See the challenge as an opportunity. You have to tone up a system. You have to think the short term and medium and long term. If you use this opportunity well, you can streamline the whole thing for the future.
Yes, accepted and noted.
And you can ask for resources. You can say there is a crisis, there's an urgency. Please give me resources and push it forward now.
Certainly, sir. Certainly.
You say today's. Do you have to say something?
No, Mark, not.
My lord, I just wanted to bring to your lordship notice that they had filed an affidavit on the last date.
Yes.
In page 7 of the affidavit, they have said that involved Sarpanch and PRI members.
Correct. That's what I'm asking. Who are these Gaja Sathis and what will they actually be doing? You say today's hearing has been advanced on account of some a development that has caused deep concern. Stop. This is the discovery of the carcass of a poached elephant.
Male elephant.
Sorry.
Male elephant.
Male elephant.
In Similpal South Wildlife Division.
Which was thought to be, which took place around 7th December 2022. and the evidence of the theft of the tusks and burning of the carcass by forest officials of the Jenabil range, Simlipal South Division. Full stop. The court has been given a written status report by the Deputy Conservator of Forests of the Joint Task Force, stating that all they could find were a few bones and flesh from a waterfall / stream, wherein the alleged burnt matter was disposed of by the said forest staff. Full stop. It is stated that the 3 forest officials have been placed under suspension by the Field Director (STR). Paragraph. Mr. Manoj Nair, the PCCF, was present in virtual mode. Full stop. He states he is right now stationed Simlipal itself to ensure that the inquiry is taken to a logical conclusion. Full stop. The court has impressed upon Mr. Nair that it would like to be assured that preventive steps that were planned by the Joint Task Force (JTF) are actually put in place immediately. Full stop. An affidavit listing out the exact measures taken will be filed before the next date. Full stop. This will include the names of the single quotes Gaja Sathis, unquote, who are said to have been deployed, and the map showing the elephant corridor routes in state of Odisha, with the names of the villages that will fall in and around the corridor. Full stop. This affidavit, you say list on, we'll have it
22nd.
22nd. All right. List on 22nd December.
Mr. Nair will be present on that.
Yes. Mr. Nair will remain present in virtual. Mr. Nair, there is a great expectation and hope that you will set things right.
Sir.
Please don't disappoint us. Yes.
I'll kindly note that it will be taken up at 10:30.
Yeah, at 10:30. All right.
Noted, sir.
All right.
Thank you, sir. Thank you very much. Cheers.
The order was this registering of the FIR. I don't know whether that report said that. Whether the case has been registered.
Yes. Now that the issue report
has come back. That report I have also filed. Thereafter, it will be.
Thereafter, Milan.
No, but under wildlife, be given the FIR number and all that. Please tell him that.
I think FIR is not yet registered because we are awaiting for the report from the
So this much information is enough to register an FIR.
Yes,
Once the forest officials are suspended, you know this has happened.
Yes.
FIR should be registered immediately.
Immediately.
Yes. In fact, we should.
Mr. Nair is there.
Anyway, we should not do anything more at this stage. Yes.
Supplemental list, old matter, item number 1. My lord, item 1, I'm appearing through VC. My lord, this is for acceptance of the late filing of the postal requisites, my lord. My lord, this have already been filed, my lord.
Alright, the postal requisites already filed belatedly. We accepted for fresh notice to be issued. Returnable, 12th April.
Gratefully, lord.
Item number 2.
Item number 2, yes, state appeal, my lord. In this case, my lord, in the last occasion, yesterday, my lord has already passed an order on WA number 337 of 2016 and posted to 15/4/2023 for hearing. So let the matter on count 15/4/2023 along with 337 WA number 337 of 2016. Similar matter, my lord. Yesterday, my lord has posted to 15/4/2023. WA number 337 of 2016. So let the matter come on that.
How is it similar to that?
That is a similar matter. The similar matter, man.
What's the delay? There's 301 days, sir. Delay. What is the explanation of the delay?
May I place, my lord?
Yes.
My lord.
Para 5, just come to para 5 of the application. Same story. File is moving from here to there.
But let the matter come on Monday at least. Monday.
No. What Monday, Tuesday? Just come to the application.
My lord, kindly peruse Annex to 16. I am challenging the Lord single judge.
So first explain the delay, 301 days delay. Please explain that.
Delay, my lord. A file also condolence question.
Who's for the state?
School math.
Which
He
is
appearing for the state.
School and math.
Now he's appearing for the state. He's got into the panel. You have got into the panel, correct?
Yes.
He's seen you so much for the other side. He's presumed that
you come to
the
this
other
side
side.
now.
You have to stand here. That's all right. So,
we are highly discriminated.
So you are also new to this. You are also new to this condemnation of delay. You will find this at 90% of the matters. So you better be prepared for it now.
Had it been Mr. Mahapatra by now, would have succeeded. The official procedure, my lord. My lord, the miscase, my lord. Miscase 199. IA 199.
Correct. We have it, sir. We are already in para 5. You are coming to it now. There's no explanation. You will now get a whole gear up with other set of case law now.
Yes, ma'am. May play, let the matter.
No. There's nothing in this. There's a delay of 301 days in filing this appeal, which is not explained at all properly. The delay is purely on account of administrative reasons, which has not been acceptable even to the Supreme Court of India in a series of full stop in Postmaster General versus Living Media India Limited and State of Madhya Pradesh with Berulal. The Supreme Court has insisted on proper explanation by the state for the delay in filing its appeals. Paragraph. Consequently, this court declines to condone the delay in filing the appeal. The application is dismissed. Consequently, the writ appeal is dismissed. Nevertheless, the question is left open for decision in some other appropriate case. All right. Contempt case, you just say now placed before the roster bench of the single judge on 18th January.
Supplementary list item number 3.
May I please, your lordship?
Yes.
It's become infructuous.
All right. Dismissed as infractions. All of this. Both the matter. Single judge. What is that single judge matter doing here?
Item 3. Dispose. Infructuous. Okay.
It is a matter of trust board, formation of a trust board, my lord.
That is infructuous.
All right. Disposed of as infractions. All right.
Item number 4.
Item 4, lordship has already dismissed the writ appeal. That is in WA number 488 of 2017.
Same order. All these writ appeals go. Both these writ appeals. All right.
Item number 5.
Plus item 5, I've got the.
That order is corrected. Okay. Item 5, who's for the?
Lordship, I am for the petition. Lordship,
the disciplinary proceedings have been dropped and he has been reinstated since 16th of April.
All right. The counsel for the state informs the court that the disciplinary proceedings have been dropped and the appellant has been reinstated.
Lordship.
In that view of the matter, no further orders are called for in the present appeal. They disposed.
The main issue open, Lordship, to challenge because.
All right. The main issue is left open for decision some other problem.
Lordship, Lordship.
All right. All right.
Item number 6.
Please, Your Lordship, I am permitted to argue on behalf of SP Shashwat, my Lord. My Lord, the second copy, my Lord, I am serving filing, my Lord.
Tell us what the matter is about.
Yes, my Lord. This is a matter, my Lord. My Lord, petition, the appellant has challenged the order of the Honorable Single Judge, my Lord, under Annex 1. The background of this case, my Lord, like this, my Lord. The government, my Lord, enlisted the civil engineer's diploma, my Lord, under the chairmanship of engineer-in-chief, my Lord, and B department, my Lord. My Lord, the Lift Irrigation Corporation, my Lord, requested to the chairman, my Lord, to sponsor the name of a civil engineer diploma, my Lord, for appointment as a junior engineers, my Lord. My Lord, in view of that, my Lord, but the appellant was not communicated any letter so far, my Lord, in view of that, my Lord. My Lord, Lords, you can have a glance on Annex 2, my Lord. The Lift Irrigation Corporation, my Lord, appointed the issue appointment order, my Lord. Lords, you can have a glance, page 14, my Lord. Serial number 1, the name of the appellant, my Lord. My Lord, selecting him as a junior engineer, my Lord, also issued.
No, but you filed the writ petition in 2017, sir. The selection was in 2012.
12, my Lord.
You never came to the court till 2017.
My Lord, the petition has no knowledge about the selection, my Lord. Because, my Lord,
you can't keep quiet for 5 years, sir.
My Lord, I have given a citation, my Lord. My Lord, which, my Lord, the another person also in belated stage, my Lord, made representation, my Lord.
He gave his joining in 2012.
Yes, my Lord.
So you are coming in 2017. It's not
because, my Lord, that no communication was made. The list was maintained by the chief engineer, my Lord.
Yes.
So no communication whatsoever, my Lord, to the appellant, my Lord, at the relevant time. After having learned about the selection, my Lord, he made a representation in the year 2015.
We don't know all that. And you can't go on making representations. That's what.
Now, my Lord, the petition is age bad, my Lord. So that has not been taken into consideration.
Then it's anyway infructuous.
No, age bad means, my Lord, overaged. Overaged.
So anyway he can't join.
But, madam?
So anyway he can't be taken.
Yes.
Then what's the point in this appeal?
Overaged. That question was not taken into consideration by the Honorable Single Judge, my Lord. Since he was selected candidate, he is placed at serial number 1. No communication was made. But since when he learned about that selection, he made representation. Right. Another person also made a representation. He was allowed to continue.
Or you say the challenge in the present writ appeal is to an order dated 5th February 2017, passed by the learned single judge, dismissing the appellant's writ petition civil 25760 of 2017. Paragraph. The challenge in the writ petition by the present appellant was to an order dated 20th November 2017, rejecting his representation that he should be permitted to join in the post of junior engineer (civil), notwithstanding that the joining date had long been crossed. Paragraph. The background facts are that 20 diploma engineers bracket civil, including the present appellant, was sponsored to the Lift Irrigation Corporation Limited by a letter dated 25th November 2011 of the Chairman, Committee and Chief Engineer and EIC bracket civil, Odisha, Bhubaneswar. Full stop. The Managing Director, Lift Irrigation Corporation, issued an engagement order in respect to the said 20 diploma engineers, including the appellant, by letter dated 16th April 2012. Full stop. According to the appellant, he was not aware of the above development. And had been approaching the authorities by submitting representations for sponsoring his name. Full stop. He claims that he was neither intimated about the fact that his name had already been sponsored, nor of his posting to the Lift Irrigation Department, Bhavani Patna. Full stop. It is only ultimately in 2017 that his claim was rejected by a letter dated 5th June 2017 on the ground that he ought to have joined the place of posting within 10 days from the issue of the order. Paragraph. The case of the appellant, both before the authorities and before the single judge, was that another person in whose favor the posting order had been issued was allowed to join more than 6 months after the posting order. Stop. As noticed by the learned single judge, no parallel could be drawn with the said person he had reported for duty in 2012 itself, whereas the present appellant waited for 5 years to even file a writ petition in the High Court in the first instance. Paragraph. Considering the appellant is not able to satisfactorily explain why the appellant waited for 5 years to approach the court for relief. Stop. The mere, as pointed out by the learned single judge, merely filing representation one after the other over the years would not explain away the obvious laches on the part of the appellant in seeking relief. Paragraph. Consequently, the court finds no reason to interfere with the impugned order of the learned single judge. The writ appeal is dismissed.
Supplementary list, fresh submission, item number 7.
Item number 7 and item number 12 to 18 is from a common order, and your lordship has already considered 3 OTA appeal and has given a verdict against the department.
All right. You say item 7
and 12 to 18.
12 to 18. All these appeals stand dismissed in view of the judgment dated 29th November 2022 of this court in OT APL numbers 10, 12, and 19 of 2010. Bracket. The Commission of Central Excise and Customs and Service Tax versus Tata Iron and Steel Company Limited. Right. All right.
Item number 9.
8 is over, is it?
Name of Tushar Kanti Satpathy may be recorded for respondent.
All right. Tushar Kanti recorded for the respondent. None appears to the petition dismissed.
Item number 8, my lord. Item number 8.
Mr. Chimanka, it was mentioned by Mr. Rai, so it's been adjourned.
Okay. Thank you, sir. Thank you.
Item 9.
Just dismissed it, sir.
Item number 10.
May I please, sir? Lordship, in this matter, initially I have challenged the SOCO's notice, but actually DRC 07, the assessment order under section 74 has been issued, which has been brought on record by IA number 5835 of 2022. So now, your Lordship, I may be permitted to file appeal challenging the order.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to challenge the order dated 9th March 2022 in accordance with law. by way of an appeal.
Let's see the pending sub-writ petition.
If the appeal is filed not later than 1st February 2023, accompanied by an application for condonation of delay, explaining the delay on account of pendency of the present petition, it will be considered in accordance with law by the appellate authority. The court clarifies it is not expressed in the matter.
Progress.
At no 11.
May please, Lordship. And here the petition has challenged the order passed by the government under Annexure 8 at page 30. Now, it relates to a number of writ petitions were directed to dispose of. By common order has been decided. Now, here the finding is that this is regarding special COVID fee. They imposed 50%, and after 3 months they reduced to 15%. So about 35% we have made claims. The secretary has rejected all the representations of the petitioners on the ground that there will be floodgate will be opened. If relief will be granted, then it will be similar matter. Lordship has accepted already.
Where is that?
And it is date is fixed to 20th of February 2023. Lordships have directed file counter and rejoinders. But I have got one case number, so. Now the last page is WPC 27858. That is your Lordship's order. First.
All right. It's a notice.
First was notice was issued.
Notice. Reply within 4 weeks. Rejoinder for the next date. List along with WP Civil 27858 of 2021 on 20th February 2023. All right.
Obliged.
Supplementary list item number 19.
None appears dismissed.
Item number 20.
Same all.
Item 21. Item 20. I am for the Union of India.
Or
Item 21.
May I please, Lordship, item 21 on behalf of my Lord. I have no instruction in this matter.
No instructions dismissed.
Item number 22.
Same.
22 also same.
Item 23.
23.
19, I am for the petitioner matter. The petitioner died in the meantime. Steps may be taken for substitution.
Not at this stage. The limitation also steps are not taken. You say the counsel for the petitioner 19. You say counsel for the petitioner informs that the petitioner has died. So it is seen that defects were not removed for 7 years. Even steps for limitation have not been taken. Consequently, the court is not prepared to entertain the present application. It is dismissed.
Item number 23.
None appears dismissed.
Item number 24.
None appears dismissed.
Item number 25.
25 matter, earlier dismissed matter. And today I am appearing. No instruction Lordship may pass cleared.
No instructions dismissed.
Item number 26.
51.
None appears dismissed.
Supplementary list item 27.
None appears dismissed.
Item number 28.
My Lord, this is a covered case by the Honorable Court, Odisha High Court. I want to submit some cases.
Yes, please.
My Lord, the petitioner has made 2 separate contracts with the parties to sell boulders and to transport blood boulders. There are 2 separate orders from the beginning before the amendment of the definition of sale on 1st June 2008. And that work order and agreement has been accepted in two forums, that is from the assessing authority, and the second is the first appellate authority.
What are these defects? 6A992. Certified copy not filed. So certified copy is not filed till now, so 6 years over now. Because last 6 years you have not filed certified copy of the judgment of the tribunal.
No, yes, sir.
Are you aware of the defects or you're not aware?
And today I have awarded. Today I have seen.
You've seen? You're not cured?
Yes.
Yes or no, sir? Have you cured the defect? You've not cured the defect?
No, sir.
You have not. All right. Last opportunity, the petitioner to cure the defects within a week. List on 31st January. All right.
Item number 29.
My lord, may I please your mind? My lord, questions of law is at page 8, my lord. Paragraph Roman 2, my lord. Page 8. Copy notes. I'll solve the copy in course of the day.
Yes.
My lord, question number Roman capital 2. Whether the order of the tribunal is perverse and bad in law, inasmuch as the tribunal proceeded with a wrong footing, that voluntary disclosure or payment of higher amount of tax was made after receipt of the notice for tax audit, particularly when voluntary payment of tax was made on 21/4/2012, Annexure 1, whereas the notice for tax audit was issued on 4/5/2012, Annexure 2. Third, my lord, the third question, whether on the facts and in the circumstances of the case, the tribunal is justified in not giving credit of the voluntary payment of tax towards tax due by applying section 33(5) of the OVAT Act by holding that the payment was made.
Tax effect here?
My lord?
Tax effect. Tax effect.
Tax effect is 4,40,000.
All right. Notice, CXF's notice. Both on the application for delay as well as this. The dispensing with is allowed. List on.
Delay may kindly be condoned after 43 days because of the lawyer strike by the Odisha High Court Bar Association. The delay was caused.
Never condone all these delays.
My lord,
we should never condone, sir. We should never condone these delays. We have made a big mistake in going on like this.
My lord,
you are aware of the orders of the Supreme Court.
Yes, my lord.
This has gone on for too long, sir.
My lord, this is relative.
All this has gone on for too long.
My lord, this is
you have all tested the patience of our courts for too long.
That is unfortunate, my lord.
No. And what is most unfortunate is litigant suffering.
Yes, litigant suffering.
Yes. No accountability. All right. Notice on this delay.
My lord, my lord.
Item number 30.
Item number 30, my name may be deleted, my lord.
All right. Then name of Mr. Satyajit Mishra be deleted. None appears for the petitioner dismissed.
Item 31.
31.
Next. 31. Item number 31. Well, I am removing the defects, my lord. Limitation is actually 2 days, not 73 days. 2 days, I have misplaced the original order, so I applied for certified copy. After the certified copy has been up to delay has been occurred for filing of the case, my lord. I have explained that, my lord.
Get it numbered, sir. The application be filed in the registry. Let's leave it back. Because the SR has to be made for this. Counsel for the petitioner states that he'll be filing his application for condemnation of delay today. List on 20th April. 20th April.
Item note 32.
The delay. 107 days delay.
Yes, my lord. I have explained that. This order was received by the manager of the proprietor who was misplaced. After knowing from the tribunal, I applied the certified copy. Thereafter, filed the appeal. I explained each and every day.
Just issue notice on that. Notice on the delay application, he accepts notice. 20th April.
That's the question of us.
No, we'll wait. We'll see the
Item 33.
Mr. Chimanka is on virtual mode.
No. You're for the petitioner?
Oh, sorry, 34. Sorry.
Item 33.
None appears dismissed.
Item number 34.
Mr. Chimanka. It's under a tree. You're standing under a tree.
Yes, my lord. At Puri.
I see. All right. Yes, tell us.
Yes, we'll file a fresh notice to the sole respondent within 7 days with correct address.
All right. Last opportunity to serve the respondent. Fresh notice returnable. 24th April. Yes.
Anywhere you stand,
Correct.
you can
Participate. Correct. All right.
Item 35.
Same.
Same order, my lord.
Same order. All right.
Item number 36.
36. None appears dismissed.
It's my lords have asked for if similar matters were pending. This is with regard to the shifting of the WODC, the Western Odisha Development Council headquarters. I found two petitions they filed. Both were disposed of with regard to representation.
Right, anyway, nobody's appearing today. All right. Just keep this. All right.
Item 37.
Well, it's 37. There is some defect pointed out.
Yeah, defects we cured. Yeah, defects pointed out we cured within a week. List thereafter.
Item number 38.
I kindly allow 2 days for removal of the defects.
All right, defects we removed within a week. List thereafter.
Item 39.
Defects.
Well, this can be ignored, my lord. The margins are not there, names are not in capital letters. It was filed in a hurried manner, that's why.
You've already earlier, the same person came earlier, no?
Yes, my lord.
It's
a very good PL actually. My lord, the substance of the petition is on para 8 at page 3. We are seeking certain direction from the from this honorable court to the government.
Mahanadi Bank facelift.
No, I've cited kind of glance on para 8.
But why are you not first making a representation? For all other things, you people make representations.
No, these are actually to be decided by this honorable court.
No, what? Why?
Because may I read para 8?
No. There is some project according to you which is without getting objections from the public, correct?
Yes, my lord.
And actually,
most of the projects.
No. These are, if there's an environmental angle, you go to the NGT.
No, what I am asking, my lord, kindly turn to page 9. Sorry, page 6. The prayer portion.
This is a broad sweeping thing, sir.
Yes, because
which project is this?
Any project.
No.
My lord, kindly see.
Cut.
The problem is whatever project they are doing.
See, what you people do is read the newspaper.
No,
morning you come across a news item. You say, this becomes PIL, let's go file a PIL.
No, my lord.
No basic, sir, some basic homework.
I have done my research. I've seen that lot of projects are coming, the government are coming with no prior approval. Then there are litigation in the High Court and Supreme Court.
Okay, on this is one news item you have placed.
I'm citing 2 examples. One is that Sri Jagannath Heritage Project and latest one is Borfi project in Cuttack.
Where is it? Where have you mentioned this? Where have you mentioned
at para 13, my lord. Annex 1 series.
No. This Jagannath thing is already part of another earlier writ petition.
I have just cited that these are the problems we are facing. We are coming to the court. They are unnecessary litigations.
No. This is too vague, sir. This is too flimsy. You have to do proper research. You have to give us dates. When did you first hear of the project? What effort you made to find out about that project?
These are legal mandates.
And you have so much RTI, everything. You have to do some basic homework.
So by the time,
you can't throw all the burden on the court legs.
Can you see the prayer? These are genuine demands.
That's the whole problem, sir. Demands may be genuine. How to go about it is the problem. See, somebody is coming to you as a lawyer for correct advice, correct?
Yes, ma'am.
This is not the way to do it. Such broad sweeping prayers.
They are not giving any instruction. There is no legal sanction, no permission.
Have you written to the government asking for information?
They are doing illegal things. It is the court to duty.
Sir, if this is the way you're going to argue, then there's very little we can do. Have you made the effort of actually filing an application under the RTI Act asking for information from the government?
No, I'm not against any project. What I am saying is that, kindly bear a moment. What I am saying is that whenever there is a development work, it attracts a lot of litigation in the High Court, Supreme Court. So what I am saying, if this direction will be issued, there will be no unnecessary litigations. There will be no wasting of public time and money. So in a democracy, we must know.
You're mistaken about that also. But anyway, we do not want to get into an argument of that. On these projects you've mentioned in para 9, is it? Where have you mentioned?
Para 8 and para 9 and 13.
13. Okay.
I just give an example. It's already decided.
You bring to us instances, not already decided, instances where, according to you, a project is going on, where no information is available, where no objections have been invited from the public. Give us those live examples. And before you bring us those examples, you have to do some homework. You have to make the effort of either under the RTI, writing to the government, asking for information. You have to give us copies of that applications that you make under the RTI, where you have not received a reply. Not receiving a reply under the RTI has its own consequences. Here, nothing has been done. This is a how much 5-page petition?
I'm not on
casual.
What I am saying is that whenever a government declares a development project, it invites a lot of litigation in the state of Odisha. We went to the court. Again, this is clear. Now, before that, if these certain guidelines will be issued, there will be no litigations. May I? The process will be more transparent. It is actually we are giving an opportunity to the state. They do this. There will be no litigations. There are piling of cases in the High Court and Supreme Court. So unnecessary litigation will be reduced. Public money and time will be.
Yes, that's what you mean. This is all badly informed, sir. Actually, the problem is these kind of petitioners do not know how the system works. They just rush. They read the newspaper. They think something has to be done. Go to the court.
We have experienced here this Jagannath project case.
If you do not know how to go about, you see, like for instance, you have ailments in the body, right?
Yes.
You have an eye ailment. You go to the ENT specialist. What is he going to do? You say, no, I have got an ailment. You have to do something about it. Will he do something about it? You should know how to go about things. Every problem, you just straight walk into the court. With one 4-page petition, no homework, no research, nothing. And just put it on the court's thing and say, now you deal with it.
This difficulty is apparent. I was seeing that. Unnecessary litigations.
See, the problem is you people try also to justify this kind of a badly drafted petition, vague prayers, but you stand up and say, no, you have to do something about it.
I'm not justifying. I'm praying before my Lord.
See, we have nothing to say. If you are very happy with the kind of petition you brought before us, we have very little to say.
I'm learning.
You may be happy with whatever you have done, sir, but it's not it's sufficient for the purposes of the court to interfere. We require much more serious petitions. We require much more homework to be done by a public interest litigant. This is not for a casual, just 2 pages, just throw it into the court and say, now you deal with it.
The whole picture is there within these 2 pages.
Those days of casual PIL, just whatever we tell you, you still have to entertain and issue directions are all over. You better do serious homework. This is a message to your client. If you think you have done serious homework, we don't agree with you. Anyone reading this 5-page petition, just distribute it in this every person.
But the entire material facts are there.
I see. This is what you think. This is the problem, sir. You as a lawyer are very happy with the petition you have drafted. And it is a totally inadequate petition with vague prayers. I'm sorry to say this.
Okay,
PI litigants have to be far more serious. You're engaging a court's time. You have to be far more serious, sir.
Sir, exactly. We don't want to come to the court.
You may feeling strongly about an issue is not the same thing as doing proper homework, proper research, then coming to the court.
My demands are genuine. In a democracy, the government must share what they are doing.
You wish to do something, otherwise we'll have to dismiss it with costs. You'd make up your mind what you want to do. It's a sheer waste of court's time. This kind of petition.
I'll file a better petition.
Counsel, the petitioner seeks leave to withdraw this present petition to seek proper remedies in accordance with law. Dismissed, disposed of as withdrawn with liberty is paid.
Item number 40.
Item 41 and 42, my lords.
Yes.
No instructions, my lords.
Dismissed, no instructions.
Item number 43.
Lords, I am appearing for the petitioners in 43, my lord.
Your lordship, item number 43. Item number 43 is regarding the 2J, your lordship. 2J, section 2J of the Odisha Anti-Tax Act. That batch, your lordship has fixed on 6th February 2023.
All right. What? Give us one number in that batch.
Your lordship, that 21,892. 2012 is the lead case in that batch. HPC Limited
of 2012. List along with that petition on
6th February.
6th February 2023. All right.
Obliged, my lords.
All right.
Item 44.
None appears dismissed.
My lord, 45. I have been instructed to appear
here.
There is some defect. Time may kindly be given.
Mr. Mahanti states that he has now been instructed to appear for the petitioner. Defects be cured within a week. List thereafter. All right.
Item 46.
46. My please, your lords. But this is my lord, the challenging the finance department circular. Your lordship, Horace Maji is pleased to dismiss. Lord, one fact, your lordship submit that all the matters has been is pleased to issue notice by Honorable Apex Court and 4th January. I am only liberty may be granted if any order passed to revive the applications.
Fine, we'll take this there also. This also can go there. In view of the decision of this court in Harishchandra Maji, the petition is dismissed. All right.
Obliged.
Item 47.
My lord, appearing for the item 47, my lord.
Right.
Sub item 1 and 2, my lord, your lordship have already issued notice. As matters are fixed in other cases, my lord, similar matter, for 25th April, my lord say.
All right. List on 25th April, along with?
Along with, my lord, SDS is the lead matter, in fact. Other matters are, my lord,
WPC number 29186 of 2021.
29186 of 2021. Okay. On that day.
Third sub item, my lord, notice is not issued.
All right. You say third sub item, notice returnable on that date. All right.
And what I pray, Commissioner has filed some decision relying upon. If a copy can be given so that man.
All right. So could we please give him copies of the decisions you relied on?
I will do.
I have already filed, my lord.
All right. All right.
Counter, they have not filed, my lord. Counter is not served at.
My lord, so
first two matters, my lord.
All right. Copies of the counter affidavit be served on counsel petition. All right.
Obliged, my lord.
Item number 48.
My lord, item 48. Some defects are pointed out.
Defects be cured within a week. List thereafter. All right.
Item 49.
Item 49, my lord, some defects are there.
All right. Defects be cured within a week. List thereafter.
Much obliged.
Item number
49, I am appearing for the department. In 49, I am appearing for.
All right.
Item number 50.
May I please?
Yes.
Lord, in this case, my lords, the audit procedure is completely provided under GST law. There are at least 3 requirements of that, my lords. Prior to issuance of final audit report, my lords, he has to look at my books, my records and my evidences. It is quite normal, my lords, and provide statutorily also. He doesn't look at it, my lords. He refers to the report issued by my CA auditor, which, my lords, no
for AB income tax, here also there is an annual audit.
Right.
Now, my lord, that audit report has already been rectified. The department wrote directly to the CA auditor of my company.
Right.
My lord, the CA auditor says, now I have verified everything. This is the final reconciliation. He still goes by the original report, my lord. Second thing which law requires is that he has to give me a draft report. I have to provide my submissions on that. He has to consider it and then final, my lord. My lords, when he issued observations, not even draft report, observations, I gave him 12 replies because there were 12 questions raised from me. Well, my lords, one of the biggest issue here is 1400 odd crores, my lords, supply made by one factory of mine to another factory of mine within the same registration. Therefore, my lords, accounts shows it separately as sale. Why, my lords? Because I do factory-wise accounting. Therefore, I explained to them that this accounting figure, when you have to reach to GST figure, you have to exclude it because it is within my own organization, within my same registration under GST. I gave challan-wise details. I gave copies of, my lords, the e-way bills. I gave copies of challans. And, my lord, what strangely he does is, my lord, he gives me 7 days time in writing. But then what he says, I have not filed anything. 12 replies on record. My lords may have page 400.
No, but Mr. Agarwal, we are still at the stage of show cause notice and audit report.
That's right, my lords.
But this,
yes, my lords.
So now set aside the audit report. How does that arise?
Yes, my lords. Lord, I'll explain. My lords, may kindly have 2 subsection 13 of the GST law for a moment.
All right.
My lord,
no, on the show, tell us the status on the show cause notice. You filed a reply.
Right. My lord, I have not filed a reply to this notice. I have come straight away to the honorable.
Why?
Yes, my lord, I'll explain that. My lord, may kindly have this, my lords. And my lords, according to me,
I have given the court order that has been taken into consideration. He will reply to the show cause notice. Similar order has been passed by this honorable court.
But I have also got several orders. My lords, have passed 10 days before, my lords, setting aside the audit report, my lords. I have brought that, my lords, Simon India order.
I have already submitted this order.
My lords, may kindly have 213, my lords.
Right.
My lords, what I will be ultimately submitting is that the entire procedure of the audit report, my lords, which has civil ramifications on me, my lords, that cannot be done without hearing me, without considering my reply and saying I have not filed anything. And it leads to, my lords, a payment of 118 crores that I'll show prima facie to my lords. I have attached all those, my lord, 213. Audit means examination of records, returns and other documents maintained or furnished by the registered person under this act or the rules made thereunder or under any other law for the time being in force to verify the correctness of turnover declared, taxes paid, refund claimed and input tax credit availed, and to assess his compliance with the provision of the act. My lord, what I am emphasizing here is what the audit team has to verify is what are my records, what are my returns and what are my other documents maintained. And my lord would appreciate, my lord, these are turnovers of 15,000 crores, which they have to verify, my lord, GST against, my lords, my accounts. Now, my lord, what they are doing, instead of seeing my accounts, what they do is, my lords, may kindly have their audit report P29. Page, my lords, 401. Only one issue is before my lords in this, my lords, para number 2 at 402. My lords are there, my lords?
Yes.
402. Para number 2. On verification of GSTR 9 and 9C, the auditee has shown rupees 622 crores as unreconciled turnover. There are 2 mistakes here, my lords. Number 1, 9C is not filed by me, my lords. It is audit report filed by auditor who was not able to ascertain. I didn't show this 622 crore difference at all. And my lord, second mistake is this 622 crore has been written by CA auditor himself. That I have now verified everything and everything, my lord, he has given a reconciliation. I'll show that.
Your reply to this,
I have replied, my lord, 12 replies I have given.
No. I'm saying when you reply to the show cause notice, you'll point out all
my lords, what will be the problem, my lords? My lords may kindly see my lords may first, before moving further, my lords would see, my lords, just below the table, my lord, just below the table of this difference of 112 crore, my lords, where there is coming, please see, my lords. The auditee has not agreed to the observation and have not submitted any proper verifiable and conclusive reply. Now, my lords would see page 400, my lords. This is, my lords, the table. My lords, he says I have not given reply. My lords, this table gives 12 replies date-wise, which I have given. He says I have not given anything. Please see, my lords, and I show prima facie. My lords, what is the problem? My lords, these are all paper demand, absolutely paper demand.
No, this is not a demand yet.
Milords,
show cause notice.
Milords, no, Milord, what has happened is, Milord, what happens is, if Milord would see 65, 65 says that if he is not satisfied in the audit report, if there is a final audit report, then it shall be proceeded with a show cause notice. Now, Milord, what are these issues? These issues are of reconciliation arising from audit. Now, Milord, audit has 4 steps. Milords, I have pointed that out to my lords. Milords, he was duty bound to consider, that is the statute says so. Milords, how I am getting affected, Milords? He asked me a question. Milord may have that question, Milords. Milords would find that at page. Milords, when I provide him,
there is still a possibility that the whole proceedings may be dropped.
Milord, yes, there is.
After considering your reply to the show cause,
Milords are
may drop the
absolutely
proceedings, then
Milords, I am conscious of that.
unnecessary for us to interfere.
Milords are right. Milords would have been definitely right, Milord. But what I want to show is, Milords, they asked me this question that you have not filed a reconciliation of this 622. Milords may kindly see, they have themselves written to the auditor and auditor has replied to them. The GST auditor has replied to them that now I have reconciled. Please see, Milord, page 144.
No. So this is on the witness of the statement in the audit report.
And also in the show cause notice. Milords, what is happening?
So you have to reply.
We will do it, Milord. Milord, I ask myself what will happen. I have given 12 replies to them. They say I have not replied. Then, Milords, another authority which is required to apply its mind whether there is a ground for issuance of show cause notice also says the same thing. Milords may kindly see P30.
Yes.
Milords may kindly see what is the ground for. Only ground for issuance of show cause notice is that there is a difference and I have not given any answer. Please see, Milords, para 2.2. Yes. This is, Milord, the show cause notice ex facie without jurisdiction. Milord, I would not have definitely come before my lords if it would have been a show cause notice, Milord, where some sort of this issue was not there.
Correct.
This is, Milord, an issue which, Milord, ultimately what would an adjudicating authority, Milords would see page 407, 2.2.
Yes.
During the course of audit, notice was asked to explain the said difference of 622 crores. However, the noticee could not submit any reconciliation statement. Milord, this is ex facie incorrect. Please see P14, Milords. Annexure 14. Page number, Milords, 149. And Milords, they are false. Milords, I should not use this expression, but this is falsehood to that extent that they straight away directly wrote to the CA. And they got reconciliation from CA also. Then, Milords, I ask myself, how can they rely upon CA's reconciliation, which he was unable to do in the first round, which he has himself rectified?
Right now, all that has happened is, on the basis of whatever you say are incorrect statements, a show cause notice has been issued.
Yes, Milords.
You have to reply to.
Milords, I am not shying away from replying. What I am only saying, Milords, I am not saying I will not reply.
That all that you're telling us.
Yes.
Let's say the adjudicating authority is convinced with your answers.
Number one, Milords.
So he will only drop the proceedings.
Milords, why he will not be able to drop? Milords, may consider this also. Milords, what happens when the audit is finalized? MCM, Milords, the monetary committee, it has commissioner also. The adjudicating authority is, Milord, joint commissioner, additional commissioner rank. He cannot do it, Milords. He simply cannot do it. And Milords, why I am arguing this, Milords, would kindly consider, Milords, this audit procedure is not, Milords, something, Milords, you Milords would recall that in Milords central excise regime, Milords had quashed those rules where audit was provided when there was no statutory provision.
Rule 5A or something.
Rule 5A, Milords are right. Milords, it is still engaging the attention, Milords, of the apex court.
Right.
But in any case, Milord, that doesn't today have any bearing because, Milord, the time period for issuing show cause notice has now gone. But what I am submitting, Milords, is here, it is a statutory procedure which is provided under a statute. And there is a particular mechanism. Milords may kindly have that, 65.
All this is theoretical. Ultimately,
no, it is not. Why I say so?
The proceedings get dropped.
Milords, why I am saying so? Milord, what will happen? Milord, there are 3 stages the parliament contemplated before issuance of show cause notice. Kindly consider. And Milords have interfered in many cases. Milords, I'll give an example. Milord, when this issue came before my lords in Amedius case, that no pre-show cause notice consultation has been done. Milord, it was after all what? Milord, ultimately, assessing Milords could have replied to show cause also. But Milords, why Milords interfered? Milords have noted that after all, this is the process for engaging with the assessee so that unnecessary demand cannot be created. And Milords, that's what I wish to show to my lords. Milords, my own stock transfers, Milord, these are all paper demands. And why I say an audit, and I'm not, Milord, for a moment saying, please don't give it, send it back. Please don't ask the audit department to verify. All that I'm saying is that the verification process that is required to be done in this case is so extensively required because they are saying there's a difference. And Milord, the definition says audit requires my documents to be seen. Milord, that they don't see. If they don't see, then this audit is wholly, my lords, without jurisdiction and beyond the statutory mandate. That, my lords, would for a moment have 101 rule and section 65. That, my lord, otherwise, my lord, there are 3 safeguards prior to issuance of show cause notice, which my lords have aptly put as stating that it is a process of engaging to avoid, my lord, such like paper demands. My lord, it's a turnover of 15,000 crores in my lord accounts and 17,000 crores in GST, which is to be reconciled. My lord, the adjudicating authority is not the right authority to do it. My lord, that is required to be done by audit, and that's what the statute says. My lords, may only for a moment, my lords, have rule 101.
Yes.
My lords, para 4, 1014, my lords. 3 and 4 and my lords 5. First I read 4, my lords, then I'll go to 3.
Yes.
The proper officer may inform the registered person of discrepancies noticed, if any, as observed in audit, and the said person may file his reply, and my lord, and the proper officer shall finalize the findings of audit after due consideration of the reply furnished.
Right.
Now, my lord, I ask myself, what is the purpose of this, my lord?
Correct.
The purpose of this is to consider my submissions and then, my lords, arrive at...
Agrawal, all we'll be doing is postponing all these submissions to a stage where you will challenge the order passed to the show.
My lords, ultimately what will happen? My lords, may kindly consider my apprehension, my lords. There are 3 stages. Number 1 is audit, where they have to consider my findings. Then, my lords, the assessing authority prior to issuance of show cause notice, my lords, has to issue me pre-show cause notice consultation. Here that has not been done. It is not done at all. My lords, 142(1)(a) contains that provision. He straight away issues a show cause notice. If he would have issued that pre-show cause notice consultation, I would have understood. I would have explained to him. Probably he would have asked the audit department.
Because of your experience, you foresee what your destination is. My lords, because of our experience, we know that the journey itself can be aborted.
My lords, I am only saying this because my lords have recently, in this case, my lords, Simon itself, you pass on the period. My lords, I pass on my lord's own judgment, my lord. My lord, my case is no different from this, my lord. And my lord, I am not saying that don't ask them to verify. My lord, not even for a moment I am saying don't ask them to verify. I am saying that audit is the proper place to get these verified. And I'll show what has happened, my lords. My lords may only see serial number 7, my lords. And my lords, Sahara India Supreme Court says even in of audit is stigmatic. Here, my lords, they have culminated without following the process, my lords. 7, my lords, page 46. My lords, here also they have not given me any draft report, my lords. My lords may notice that. My lords have extracted the same rule 1014 at para 3, my lords.
Right.
Then, my lords, he points out that there is no opportunity to file a reply. Same day audit report was issued, my lord. Ultimately, principles of natural justice, audit, and my lord, reverted back to that same position, my lord. Para 9.
Right.
On a plain reading of section 65(4) together with 65(6), it is plain that procedural requirement having to be given 30 days time to file a reply was not followed in the present case. And my lord, here even the report has been issued after the statutory timeline.
Right.
If my lord would see, my lords may kindly notice those 3 timelines. And my lords, first, my lords, let me complete reading of this. On that ground, this court sets aside the final audit report.
Here they've gone to the next stage of show cause notice. This, you point out this judgment also.
Millards, ultimately what will happen? Millards, what I am submitting, Millards, is that the commissioner himself is a part of the MC.
What will happen is Mr. Puneet Agrawal will be kept busy.
No, Millards, with my lord's grace, Millards, I am able to, Millards, fend for myself, do something. Millards, my humble request is, Millards, in this, Millards, if this is allowed to sustain, Millards, then audit would always be perfunctory like this.
We're not going to enter the merits. We're not sustaining anything. We're just postponing your arguments on this to a different stage.
Millards, in that case, Millards,
yes.
In that case,
yes.
Millards, may I suggest this, Millards?
Yes.
In the meanwhile, Millards, let for a moment, Millards, let this show cause notice not be proceeded with. For a moment. I'm not saying quash it, stay it, do anything. No, I'm not saying that. I'm only saying, and Millards, I'm not even saying that take the grounds of limitation, etc. also. What I'm only submitting is, let the audit team, pending this show cause notice, let it remain, Millards. Pending this show cause notice, let the audit team, Millards, why I am saying so is, my accounts have to be verified and my 500-page 12 replies, Millards, that I have submitted is to be verified. What I am submitting is, Millards, let the audit team give a proper report after considering that. If he still wants to, my lord, proceed.
In response to your show cause notice.
My lords, that, my lords, if my lord, our audit team has already given the report, my lords.
Nothing stops them
My
from.
lords,
There are superior officers who can set things right.
My lord, this is the case.
They're supposed to.
What I am submitting, my lords, is this is the case, my lords, where they have completely used up their jurisdiction.
Right.
My lords, they are ex facie there. What they are noting is that I have not submitted anything. And my lords, what I have submitted, that also I wanted to show to my lords. My lord, they asked me a question. When they my lords, when they asked me this reconciliation, my lords, may kindly have that for a moment, my lords, P14. My lords, page 149.
Yes.
My lords, I submitted this reconciliation, my lords.
Yes.
My lords would see in connection with above, we now obtain the revised turnover reconciliation, which is attached as an one.
Right.
My lord would see next page, my lords. There are several items of reconciliation, my lords.
Correct.
My lords would only see one or two, my lords. The fourth one is intra-unit stock transfer of 1,468 crores, my lord.
Right.
My lord sees that, my lord?
Yes.
Now, my lord, I beg to submit before my lords that what is the reply that I gave to this, my lords.
Yes.
My lords, may kindly, my lords, come to page 157. My lord, why I am, my lord, slightly, my lords, requesting my lords look into this is, my lords, this is absolutely a paper demand. I've given 100% recognition. Only that has to be verified. And my lords would see, my lords, reply to serial number 1, page 157, my lord.
Yes.
My lords, it may be seen at serial number 6 of the annexure 1 that the amount of 1,468 crores is included in total turnover of 1,590 crores. My lord, what is this 1,590, my lords? That is the starting point. That is the starting point of my accounts. If my lord would
stop transfer.
No, my lord. My lords, what I am reconciling is my accounts turnover, which is 15,900 crores, with my GST turnover, which is 17,000 crores and odd. They say you reconcile this. Now, my lord, when I am reconciling this, one of the major item of reconciliation is that there was interest stock transfer within my same registration, which is reflected in accounts but not in GST.
Right.
My lords, they ask me a question on this. I give complete 15,908 crores ka breakup and explain within that 15,908, there is a turnover of 1,468 crores of intra-unit stock transfer. Therefore, it is to be eliminated. And I give, my lords, may kindly turn over the page, my lords. My lords would find that. Page 159, my lords. My lords, this is the complete sales ledger. My lords, item by item, my lords would only see serial number 6.
Yes.
My lords sees that IUT, inter-unit transfer, STO alumina, 68 crores. My lord, this is a part of that turnover. I show it. And my lords, the total, my lord would see on the next page that it is a part of my total turnover, 15,908 crores, my lord. And then, my lords, I give to them complete details of this, which my lords would find at P21.
Yes.
Page number 298. I give them challan-wise details of this.
Right.
So, my lord, the difference of 600 odd crores, my lord, the major item of reconciliation, my lord, complete challan-wise, page number 298.
Right.
Challan-wise details of supply of alumina, Lanjigar, so-and-so, item document number, my lords. And then, my lord would see the total, my lords would see at page 303.
Yes.
I give challan-wise details of 1,468 entire, my lords.
Right.
And I also attach with that my delivery challans on page 304, intra-unit, showing intra-unit.
See, we find it hard to believe that you will not be able to persuade the
only one
adjudicating authority with all these powerful arguments.
My lord, what is the problem with them is, my lord,
Yes.
there are two problems with them.
Yes.
Number one, they are not equipped with what is the audit team. Entire team is equipped. Number one. Number two, my lords, when the commissioner has taken a view, my lords, a joint/additional should be able to take a
that.
And my lords, third, my lord, the show cause notice says, my lords, shows the prejudice, my lords. He says.
So anyway, now you've crossed the time limit for replying, or you're still within time to reply?
My lords, I have come within time, my lords. Maybe I would have taken some time also.
All right.
He has fixed it for tomorrow. In that, my lords.
So we'll permit you to seek more time. to reply. We'll give you more time to reply. I'm sure he will not object.
That's fine, my lords. But this is a case, my lords, where he has not considered. If he would have considered even a small thing, my lords, and I am referring to my lord's judgments, then Steel Authority, my lord, Supreme Court says he should have at least.
Yes, I'm sure he will know readments.
My lords, I will show him in my lord's order that you should have read these judgments at the time of issuing.
You have enough material now. So,
my lords, in that case, if my lords are not agreeing with me, my lord, then my lords, I would only submit that my lords now, at this stage, my lords would consider my request to ask the audit team to verify my documents. I am not saying to
not saying how you should reply, what you should say.
What happens is, why I am saying so.
You to take all your submissions.
I ask myself because why I am requesting this before my lords.
Yes.
My lords, having issued the audit report,
we can note your submission and we will permit you to urge this also in reply to your show cause.
That's right, my lord. That's
all right. That's done.
But one thing which I want to submit is, my lord, that audit report, once it is issued by the audit team, they have in that sense become functus officio.
Right.
Except for my lord's direction to them that they must consider and then give an audit report without which he should not. My lord, that's the requirement of the law. That was the requirement of the law to consider, my lords.
Yeah. All right.
If my lords are not agreeing to that also, then last request, my lord. Let my lords, the assessing authority, my lords, now, let him pass a reasoned order on every my lord's issue that I raise.
Obviously.
My lord,
that's too obvious. That's too obvious.
My lords are right, but my lords, if my lord would say, then he will feel himself to be bound. Otherwise, my lord, the law saying so, he is not feeling himself to be bound, my lord.
No, obvious. That's obvious. You said the challenge in the present petition is to Roman small one.
My lords, if my lords would have considered asking them to file a reply and find out, my lords.
No. An audit report dated 1st July 2022 and Roman small 2, a show cause notice dated 21st September 2022 as a result of the said audit report. Paragraph. Having heard Mr. Pulit Agrawal, learned counsel appearing for the petitioner, and Mr. So-and-so appearing for the department, the court is not inclined at this stage to full stop. Paragraph. There are many grounds urged in the present petition, including the validity of the audit report itself. Full stop. The challenge is both on the grounds of procedure as well as substantive grounds. Full stop. The court permits the petitioner to urge in reply to the impugned show cause notice all the above points, including any other point it may have urged in the writ petition or otherwise in accordance with law. Full stop. The time for filing a reply to the impugned demand come show cause notice is extended up to 31st.
Lord, may give me 8 weeks, my lord. It is
8
very
weeks.
My lords, voluminous things are there, and I have to present all those to him, my lords. But my lords, in any case, he cannot consider the validity of audit report, my lords. That, my lords, only my lords can consider because that is not malleable or my lords anyways. Otherwise, he cannot consider it, my lords.
Up to 1st March 2023. Full stop. The authority will thereafter proceed in accordance with law and pass an appropriate order after hearing the petitioner as expeditiously as possible. Right.
Lords,
the court clarifies it has not expressed any view on the merits of any of the contentions raised in the present petition.
My lords, I ask myself, my lord, he cannot consider the audit report.
We don't know what he cannot do. We're not going into that territory at this stage. All right. Yes.
My lord, may then add at least that he will pass a reasoned order on all my grounds.
We've just said that he'll pass an order in accordance with law. All right.
All right.
Obliged.
All right. Item 51.
51, my lord, that TCS matter covered by your lordship's order.
Yes.
May I pray, my lord, other items are there, similar matters.
Yes, yes.
Item 73, 75, 77.
All right. 73,
These three also TCS matter.
Same as 51.
73, 75, 77.
But then each of them will have to change all these dates.
Yes, demand notice. Date will be as per the petition.
No. Those dates, individual facts will change in each of the 71, 73,
Then
70.
my lord, I'll file.
You better give us. Or same order.
Item 52.
Item 52, pardon, also I have removed defect number 6. 7 will remove by today during the course of the day.
All right. Defects be removed within a week, list thereafter. All right.
Item 53.
Please, Your Lordship, I am Your Lordship. May I be permitted to withdraw the petition, Your Lordship, with the liberty to approach this honorable court?
All right. Constitutional petitioner seeks leave to withdraw this petition with liberty to approach the authorities in accordance with law. Disposed of is withdrawn with liberty is prayed for.
Obliged, Your Lordship.
Item 54.
On behalf of item 54, on behalf of Ashok Mahante, will withdraw the petition and file a better petition.
All right. Constitutional petitioner seeks leave to withdraw the present petition with liberty to file a better petition. Disposed of is withdrawn with liberty is prayed for.
For admission, item 55.
May I please?
Yes.
And here the appeal filed by the appellant before the Learned Commissioner rejected on the ground of limitation, saying that there is a delay of 56 days, my lord, in appeal. But what has happened, my lord? Here the appeal was filed under section 85 of the Finance Act, my lord. Subsection 3 of section 85 also knows, my lord, there is a statutory period of 3 months and then extendable period of 3 months, my lord. Within that period, this appeal was filed. But the Learned Commission treated the appeal as it is filed under the Excise Act, my lord. So under the Excise Act, he has countable the period and it is stated that it is to be barred by limitation. But my lord, here what has happened, my lord, so-called notices were issued under the when it was demand for recovery of the service tax, my lord. It is under the Finance Act. So I filed the appeal under the Finance Act. If you have started for a 89 Annex 8, my lord, even if while rejecting the appeal on the ground of limitation, the Commissioner, my lord, while forwarded the notice for guidance, if you also see for the first paragraph, an appeal shall be filed to the Customs and Excise Tribunal at Calcutta within 3 months of the date on which the order was passed, my lord. So within 3 months, this is an appeal admittedly under Finance Act, my lord. And ST4, the appeal was filed in the in the rule, my lord, ST4. So ST4 is itself under the Finance Act, my lord. So right from the beginning, I preferred the appeal under the Finance Act. But the London Commissioner, my lord, treated it as an excise. If you turn to page 49 of the order. Accordingly, the tribunal rejected. Page 41. My lord, third paragraph. I find, my lord, got it, your lordship.
Yes.
I find from the appeal petition that the date of receipt of the order in original is on 8/12/2008. As a central excise appeal, it should have been filed within 60 days of receipt of the order in original, but the same has been filed on 4/5/2009 after a lapse of 146 days, which is 56 days more beyond the condonation limitation of the Commissioner in terms of section 35. That part is correct, wrong, my lord. Because when the demand is made under the Finance Act, so accordingly, appeal preferred under the Finance Act, my lord. So here, taking it as an excise, then next paragraph, my lord, even if the plea of the appellant is accepted for argument's sake, the appeal should have been filed within 3 months from the date of service of the order as prescribed under section 85 of the Finance Act. Still, there is a delay of 56 days in the ordinary course. So my humble submission before your lordship is that even if 56 days delay is there, but there is a relaxation period of another 3 months under subsection 3 of section 85. So taking that, my lord, tribunal rejected my appeal.
So this go to the appellate commissioner again.
Yes, I will go to appellate tribunal. I preferred, and the appellate tribunal without considering that is
succeed, it has to go back to that appellate.
Yes, I have already pursuant to this honorable court direction. I have deposited 25% of the demand, my lord. That is with the department. So I may go back to the appellate.
Kindly see page 24, Annexure 6.
Yes.
That is the order in original, my lord.
Yes.
Page 24, Annexure 6, my lord.
Yes.
Here, my lord, clause 2. Any person deeming himself aggrieved by this order may appeal against the order to the Commissioner of Appeals within a period of 60 days, my lord. This is an exercise of...
Maybe this is wrong because it is under the Act.
Yes. So yes. If your lordship remands it to the stage of appeals, my lord.
Appellate tribunal. Yes. All right. The short issue, as far as the present appeal is concerned, is whether the Commissioner Appeals and the CESTAT were in error in declining to condone the delay in the present appellant filing its appeal before the Commissioner Appeals against an order dated 29th August 2008 of the Assistant Commissioner dash Central Excise Customs and Sales Tax, Baleshwar Division. Paragraph. From a perusal of the order passed by the Assistant Commissioner from a perusal of the Memorandum of Appeal and continuation of delay petition filed by the present appellant before the Commissioner Bracket Appeals. It is plain that the appeal itself had been filed in form ST4.
Yes,
which
that is under Finance Act, ST4.
Which is under the Finance Act 1994.
Yes.
Bracket FA. And not under the Central Excise Act 1944 bracket CE Act. Bracket. Full stop. Admittedly, there was a delay of 56 days in filing the said appeal in form ST4. But the attention of the court has been drawn to
subsection 385, section 85 Finance Act.
85 bracket 3 of the FA, which permits the continuation of delay for justifiable reasons. Full stop. Paragraph. However, the Commissioner Appeals proceeded on the basis that the appeal was one filed under the section 35 of the CE Act, and therefore concluded that since the appeal was filed beyond the condonable limit of delay, it could not be condoned. Full stop. The order dated 17th August 2009 of the Commissioner Appeals notes that it was the appellant's argument that this was an appeal under the FA, and noting this alternative plea, the Commissioner Bracket Appeals declined to condone the delay on account of the illness of one of its employees. Full stop. Paragraph. Interestingly, the covering note with which the appellate order was enclosed and dispatched to the appellant notes in para 1 bracket A that an appeal shall be filed to the Sistat Kolkata bench, open quotation, within 3 months of the date on which the order thought to be appealed against it is required by the appellant in terms of section 85 of the Finance Act 94, unquote. Paragraph. Therefore, there was no mistaking the fact that the appeal had in fact been filed under the FA, and limitation therefore had to be determined in terms thereof. Paragraph. This point appears to have been overlooked by the Sistat as well when it dismissed the appellant's further appeal. Paragraph. For the aforementioned reasons, the court sets aside both the orders of the Commissioner Bracket Appeals as well as the Sistat and restores the appellant's appeal before the Commissioner Appeals to file the file of the Commissioner Appeals. Full stop. The appellant's appeal number 68/ST/BB SR-1/2009 will now be listed before the Commissioner Appeals, Bhubaneswar, on 9th January 2023, on which date the appellant will remain present through an authorized representative. Full stop. The Commissioner of Appeals is requested to dispose of the said appeal in accordance with law, after hearing the appellant and the department as expeditiously as possible and preferably within a period of 4 months thereafter. The appeal is disposed of in the above terms.
Your Lordship may indicate, pursuant to your Lordship direction, I have deposited 25% of the amount before the department.
All right. The appellant informs the court that pursuant to the directions issued by this court in the present appeal on
29/3/2012.
9 March 2012, 25% of the demand has been deposited with the department by the appellant. All right.
Item number 56.
Plus item 56, my lord, the counter is ready. It is just to be signed. My lord, may give me 2 days. I'll file.
All right. Counsel for the state informs the court that the counter affidavit will be filed within 2 days, rejoined up the next date. List on.
Your Lordship may fix short dates so that.
January 24.
Item number 57.
May please your Lordship. It is a PAL matter, my lord. Matter relates to protection, preservation and conservation of water bodies in Kathmandu. In this case, this matter appears today as per order number 18, dated 22nd August 2022. On that date, this honorable court has directed for listing of this matter along with WBC number 13,855 or 2052. Earlier to passing of this order, this honorable court has also passed an order in order number 70, dated 2022 June 2022, my lord. I would like to place this said order if your Lordship permits, my lord. Order number 17, dated 22nd June 22, my lord. On the said that Mr. Devasis Naik, appearing for the CMC, handed over an affidavit dated 22nd June 2022 today in court, copy of which has also been provided to learned counsel for the petitioner. Let a copy of such affidavit be provided to Mr. Devakanta Mahanti, learned additional government advocate, within 2 days. Thereafter, at the request of learned counsel for the petitioner who seeks to end the same, make submission and file rejoinder thereto, if any, before the next date. List on it. In obedience to the said order and direction, the petitioner has filed the rejoinder on 16 August, my lord. I would like to draw your Lordship kind attention to the rejoinder, my lord. Rejoinder is dated 16 August, my lord. I would like to draw your Lordship attention to Annexure 3 of the said rejoinder, which finds place at page 15 to 20, my lord. That is the joint inquiry report submitted by the sub-collector to the commissioner. And a list of 66 jalasas have also been enclosed to the joint inquiry report. I would like to draw your Lordship kind attention to the said joint inquiry report, which finds place at page 15 to 20, my lord, of the rejoinder affidavit. First, I would like to draw your Lordship kind attention after going through the joint inquiry report vis-a-vis the present status of the Jalashaya. It is now crystal clear. Most of the Jalasayas have not been cleaned and renovated, as would be evident from page 16, 17 and 19. First of all, I would like to draw your Lordship kind attention to page 16, my lord. Serial number 9, my lord. Serial number 9, my lord. That is the present status of 66 Jalasaya with reference to WPC number 9451. This one, I would like to draw your Lordship kind attention to serial number 9, my lord.
The status has been given at column 11, my lord, present status. Now, JBS garden mandap constructed over the Jalasaya. It is the joint inquiry report, my lord, wherein it is very clear that the over the Jalasaya, the construction has been made. Thereafter, I would like to draw your lordship kind attention to page 17, my lord, serial number 16, my lord. Serial number 16, page 17, my lord, wherein it has, in the remark column, it has been indicated now, Odisha Cricket Association Club complex constructed over the Jalasaya, my lord. Thereafter, I would like to draw your lordship kind attention to page 19, my lord. Page 19, my lord, serial number 47, my lord. There also the Joint Commissioner also has indicated now truck and bus terminal of Pradhans over the Jalasaya. So it is
9451, I think.
at page 9. My lord, I may be permitted to draw your lordship kind attention to page 19, my lord, serial number 57. Now, two-storied building constructed over the Jalasaya plot. So it is now admitted fact as per the joint inquiry report that construction has been made over the Jalasaya. To find out what action the commissioner has CMC taken, for that reasons, I would like to draw your lordship kind attention to Annexure 2, my lord. Annexure 2 finds place at page 11 to 14, my lord, of the rejoinder affidavit. Relevant page is at page 14, my lord, wherein the PIO of the Office of the Commissioner has intimated the petitioner that no action and action taken report is available. So it is now clear that the petitioner has not taken any steps. No action has been taken regarding the illegal construction over the Jalasaya, my lord. So my submission before your lordship that some order should be passed, and if your lordship agrees, then the Principal Secretary, Housing and Urban, should explain why they are not able to clean and renovate. Only because it is concerned to the people of city, my lord, in the rainy season, and when the rain is there, hue and cry, and people are in the home arrest. Unless it is not clean, then how the people will be survive, and there will be anything to be done.
Yes.
As your lordship knows that already this issue has already been decided long back in the year 2012 by this honorable court, wherein this honorable court has directed the state to act upon the report of the RDC, CD and the Principal Secretary, Housing and Urban, my lord. And the matter should be decided and addressed within 2 years, my lord. That has not been done. My lord, kind enough to give sufficient opportunity to the state and functionary of the state to improve the situation. Instead of improving, day by day it is deteriorating. This is my submission before your lordship can give some direction so that matter can be solved.
I have a small fact sheet that I'll just like my lord to look at. Just ask the Yes, my lord, may I have a look at the first paragraph. This issue has been taken.
Give him a copy.
I'll give him a copy. The matter has been discussed a number of times. The technical difficulty is that these water bodies are in control of the state. For effective transfer to the CMC in toto. For that reason, long back, there was a draft MOU that was formulated by the advocate commissioners of this court in the earlier PIL. My lord, kindly have a look at the resolution minutes of the meeting on page 5 of that note.
Same, I think he himself referred to the same minutes.
So the minutes, there's a draft MOU pending with the government for transfer of these water bodies, and a specific direction is needed to spend already sanctioned 6 crores 70 lakhs 76 lakhs 50,000 rupees. So once that MOU is finalized, we can move ahead with actually putting that plan into action. So if some instructions are coming forth from there, then
This
we
is
can move.
2019. We are in 2022.
My lord.
What has happened? Basically, nothing has happened then.
Well, it's with regard to the status of the MOU, I'll take instructions. Yes.
See, learned counsel, the petitioner has drawn the attention of the court to the rejoinder filed by the petitioner in response to the counter affidavit of the Cuttack Municipal Corporation. According to him, very little has been done on the ground to restore the Jalasayas. Paragraph. Mr. Devashish Nayak, learned counsel appearing for the Cuttack Municipal Corporation, Bucket CMC, has handed over a single quotes appraisal note, unquote, which entirely encloses copies of the minutes of a meeting held way back on 3rd June 2019. Pursuant to the directions issued in Petition Civil 9451. Pursuant to the directions issued in the first listed Petition Civil 9451 of 2019. Paragraph. How not known whether in 3 years, more than 3 years since then, effective steps have in fact been taken in terms of that decision. So there is also an issue of the non-handing over of the Jalasayas by the state government to the CMC, which requires to be addressed. Full stop. The stand of the CMC has been that till such time the actual transfer takes place, it will not be in a position to either maintain or preserve them. Paragraph. Mr. Ishwar Mohanty, counsel of the state, seeks some time to respond to the single quotes appraisal note, unquote, submitted by the CMC to this court. An affidavit be filed listing out the concrete steps taken for revival of and preservation of Jalasayas in Cuttack City by the state government within 4 weeks from today, with an advance copy to counsel for the other parties. Full stop. List on list of PLs. January.
I would like to make small submission before your lordship. That illegal construction as has been done over the Jalasaya, the local bodies and the local authorities should take case, my lord.
That's what we've said, sir.
My lord.
That's what we just now said. We've asked them to file an affidavit listing out the steps they've taken.
The second sub-item, my lord, copies of
My lord, the other one is I have filed the consolidated petition on them. Then, my lord, I have filed it. They can take it from their office, my lord, government can take it. And the requisite, my lord, against OP number 3 and 4 are filed, along with requisite against OP number 11 and 12. 11 and 12 are added last time as OPs. So notice is necessary on them. Therefore, I have filed the requisite. So requisite was filed against OP number 3 and 4. Also, OP number 11 and 12. I have filed, my lord.
When did you file it, sir?
My lord, the other, along with the annexures, my lord.
When did you file it?
My lord, today I have filed.
Today?
Today I have filed.
The requisite stated to have been filed. The next accompanying matter, the requisite stated to have been filed today be utilized for fresh notice to opposite parties 3 and 4.
And I will file the response to the affidavit by Monday. By this Monday, I will file response to the third item, my lord, sub item. I will file my response to their affidavit by Monday.
There's no third submit.
My lord, one is consolidated, not filed. Two is requisite. Third is response. They have filed an affidavit.
All right. Well, all right.
I will file it within a
All right.
week.
Item number 58.
19. This matter, they challenge the violation of Rule 9(3) of the registration of birth and death rules. Lordship, please to grant us time to file a counter. We need some more time. Pray, Lordship may grant me some more time to file it.
Last chance is given to the opposite parties to file the affidavit on or before 1st February 2023. Rejoinder if any before the next date. List on. April.
12th April, sir.
12.
Item 59.
59, 10, 11, 2020.
Well, that's item 59. I've got the instructions. Whereas I've also got the photographs of the condition of the road post the repair. With your permission, if my lords, I can show the photo.
Yeah. You give him a copy.
This is an internal.
What is that? Is this a letter to you? So they're saying work will be completed by January.
My lord, may see the photographs.
My lord, as per my instruction, my lord, only 5 meters out of two.
He's showing some photographs.
2 kilometers, my lord. Only.
Let's see the photographs, sir.
My lord.
Showing you. There's only one photograph.
No, that's it's a P3. Just scroll down. Scroll.
What's happening? Some technical problem.
That is only 500 meters, my lord.
No, well,
out of 2 kilometers.
The chainage is mentioned in the at the bottom.
It seems more than 500 meters, sir.
The length of the road is 2 kilometers, my lord.
So it seems quite long. Yeah, January. Photographs have been shown by accepted by registry. If it is filed not later than 1st February 2023. List on 8th February.
Item number 61.
Your lordships, I prepare a password.
All right.
Item number 62.
62 infractions, my lord. All 3 items in 62.
All right. Dismissed as infractions.
Item number 63.
But 63 item, wait, please also. But there are 3 items. There's Hitansi Sales, third in Balaji Sales, and Sahu Brothers. They're actually prior to 1/10/2015 assessment in section 40. That your lordship knows that there must be an order either in section 39, 40, 42. That
Keshav Automobiles. And upheld in Rathi Steels.
Right.
So it's covered by that.
It's covered by all the 3.
All right.
No, lordship, just I want to clarify one thing only in one case, Your Lordship. Your Lordship.
No, which cases are covered? You tell us.
Your Lordship, so far as the Hitansi sale, so far as the item number 1 and 2, Joy Baba sales. These two cases, I think this is covered.
All right. So both these writ petitions, you say in view of the judgment of this court in Keshav Automobiles versus State of Orissa, bracket judgment dated 1st December 2021 in STV STREV 64 of 2016, which has been upheld by the Supreme Court in, where is that Rati Steel citation with that number? The order, we don't seem to have a copy. Even yesterday I was looking for a copy.
Rati Steel, my lord.
Where is that order copy? Order dated 13 July 2022 in SLP Civil 9912 of 2022, bracket Deputy Commissioner of Sales Tax versus Mrs. Steel and Power Limited. The impugned notices and orders in these two writ petitions are hereby quashed. Yes, third matter.
Third matter is 1/4/2012 to 34/2015. That also covered.
This is also covered.
Which one?
1/4/2012 to 34 April 2015. So it is 110 is outline.
This Balaji sales.
Yes.
This third matters and fourth matters.
No, fourth matter I'll come. Third matter is covered.
For here, Your Lordship, there is in the assessment record, Your Lordship, prior to issuance of the notice under section 43(1), Your Lordship, the returns have been processed under section 39. Your Lordship, admittedly, no communication has been issued. But on 16, this notice has been, the satisfaction and notice has been issued on 19th August 2017. And prior to that, on 16th August 2017, the returns have been processed, Your Lordship. Not, Your Lordship, in that case, I have argued that at the time, on the date of filing itself, the acknowledgement has been issued. Your Lordship has not accepted. But in these two cases, Your Lordship, acceptance has been made, this scrutiny of the returns has been made prior to the issuance of notice under section 43(1). So, Your Lordship, may kindly peruse the assessment record, Your Lordship.
No, there had to be a communication of acceptance.
Yes.
Was that there on the record? Communication of the acceptance of the return. Self-assessment return.
But deeming provision came after the...
Then you add that 846 also. Now come to 10392, sir.
To 10392, there are two parts. One part is 1/4/2015 to 39/2015. So that part is covered. So the rest part is 20th/4/2017.
It has been remanded to the AO to segregate. You see, in view of the judgment in Keshav Automobiles, this is the fourth matter, 10392. Put the citation as affirmed by the Supreme Court in Rati Steels, again put the citation. The impugned assessment order, insofar as it concerns the period up to 30th September 2015, right? 2015.
Yes.
Is hereby set aside. The matter is remanded to the assessing of authority.
Again, Your Lordship, kindly peruse the assessment record for a moment, Your Lordship, that date of assessment. Your Lordship, because acceptance shall be accepted. Section 39(2), as Your Lordship already perused. Section 39(2) shall be accepted, Your Lordship. So far as the communication, Your Lordship, you see, Your Lordship, so far as the communication, Your Lordship, may kindly...
How else will the assessee know it's been accepted? Assessee should know it's accepted. It's not enough that in your record it is accepted.
That aspect also is not varied by Honorable Apex Court.
Correct.
Your Lordship,
and in entirety, that has been accepted by the Honorable Apex Court.
So is correct? Said is correct. Is hereby set aside. The matter is remanded to the assessing authority, Cuttack 2 Circle, Cuttack, to rework the demand on the above basis and pass an appropriate order not than 1st March 2023. So for the purposes of the above proceedings, the matter will be listed before the assessing authority, Cuttack 2 Circle, Cuttack, on 16th January 2023. Stop. If agreed by the revised demand, it will obviously be open to the petitioner to seek appropriate remedies in accordance with law.
Can it be end of January, my lord?
Okay. Will be listed on 31st January. All right. All right.
Item 64.
It says after hearing the parties. Sir.
Yes, after hearing the parties.
After opportunity of hearing.
Yes, after opportunity of hearing. Right. Thank you.
Item number 64.
None appears dismissed.
Item number 65.
65, Your Lordship, this issue has already been settled. He has challenged the plot 334A by legality and validity of section, but as a plot, the Madras High Court has already decided in favor of the revenue. Your Lordship, kindly have a glance at that. 234A already decided and 234 also decided.
Oh, I see.
Same parameter program.
Okay. None appears for the petitioner. Mr. P.K. Satpathy, learned senior standing counsel for the department, has drawn attention of the court to the judgment of the Madras High Court in K. Niraimadi Aragan versus the Union of India, Manu TN 0721/2020.
Please, 3.2, Your Lordship, kind 3.2.
Negativing the challenge to the validity of Section 234 bracket
F,
capital F of the Income Tax Act 1961, as well as
234E. I am just not passing out.
F of the Income
This is
Tax
F.
Act.
This is directly covered.
All right. In that view of the matter, the writ petition is dismissed. Writ
Both
petitions are dismissed.
Both are same law. Both the writ application.
All right.
Item number 66.
May please, Your Lordship. Not here the petitioner, when I am on of licensee, but by an office order under Annexure 2, page 12, due to immersion of Goddess Gajalakshmi, they directed closure of the, in the subsequent on the Annexure 3 at page 13 on 1910, after 3 days, they said that for immersion and as well as there is a law and problem, the shop will be closed
Anyway,
for 3 days.
closure, you want a waiver of MGQ?
Yes, madam. But
where is Mr.
this
Monty?
illegal closure on account of they have said that there is law and problem, but I have resigned, I have filed, I've got the from RTI, from the concerned police station. They have stated there is nothing is there. No law and problem, nothing. And the impugned order Annexure 4 has been passed on the basis of that there is law and problem. Actually, there is no law and problem. And they have closed for 1.5 years, they have closed the shop. And they have collected the license fee. For the subsequent period, I have filed also separate writ petition. That is also posted to 23.3. Lordship, sir.
All right. List on 23rd March.
Yes, madam. Along with WPC 4074 2022.
4074 of 2022.
2022.
All right.
Item 67.
One licensee, not this petitioner, he had 3 shops in the Rourkela. Not all these 3 shops could not be settled because he was defaulted as a defaulter. He challenged those actions before this honorable court. While the writ petition was pending, the state government intended to settle these shops through lottery, issued a lottery notice. These 3 petitioners, along with one more person, they participated in the lottery process by depositing non-refundable application fee 1 lakh each month. Now, the other matter, which was before your Lordship, kindly see the order passed by this honorable court, page 4, madam. I have quoted the order. Page 4.
Yes.
Portion at page 5, last paragraph. If the intervener in WPC number so and so applies, means the applicant like us, my lord, applies for refund of the amount which he has deposited, the same shall be considered. If the intervener makes an application for refund, as the aforesaid, the same shall be considered after the shop is allocated to the petitioner, and in that event, he will be entitled to refund But if the original petitioner is not making payment within a period of 4 weeks and SOP is not allotted to him, intervener will be entitled for amount pursuant to the order of this court. Means the earlier licensee succeeded before this honorable court. This honorable court directed to deposit him. He deposited the amount and got back the license. So all those SOPs are resettled with the licensee who was before your lordship earlier. But the persons who participated in the lottery by depositing the application fee, out of 4 persons, he intervened in the other matter and direction was given to refund him. He deposits the amount. So, my lord, he got back the amount. But so far as we three are concerned, we are before your lordship, my lord, asking for the same money.
Yes. Here the question is that they participated in the lottery and it stated that it's a non-refundable amount.
No, but in all those cases, they've granted refund, no?
Yes.
This court has granted in all those cases. Why are these cases different from those cases that you have to tell us?
Yes. In fact, I've already filed a counter affidavit, and I've explained in my counter affidavit. I've stated that even those all matters were taken up together, there are no specific directions so far as refund of these bits.
No, there is. Why are you saying that? Come to bottom of page 4.
That's it. And their plea in the counter is he was an intervener, I was an
That's because the intervener and
No, for the intervener, a direction has been issued. Just come to bottom of page 4.
Yes, but so far as the intervener is concerned, lordship directed to consider and refund the amount if not found appropriate. But these persons were not the intervener. They were separate. They had filed separate rate application.
How can a person who's filed a substantive petition be worse off than an intervener, sir? Intervener himself is allowed this facility. Why can't a person who files a writ petition not be allowed? There is no distinction as far as court is concerned between the intervener in writ petition civil 22819 of 2017, who was granted the same relief as was given to by this court by its order dated
16th of
July 2019 in writ petition civil 3892 of 2017, and a person who files a substantive writ petition for the same relief as the present petitioners. So, in other words, by the above order, an intervener in writ petition civil 22819 of 2017 allowed to apply for refund of the amount deposited as long as the payment was made within, as long as the original petitioner making a payment within a period of 4 weeks. Paragraph. Consequently, as far as the present petitioners are concerned, they cannot be treated any different from the writ petitioner civil 3892, 22818 and 22819 of 2017 and the interveners in those petitions. Full stop. Accordingly, a direction is issued that if the petitioners make payment of all the government dues as demanded within a period of 4 weeks from today, their applications for renewal of license will be considered in accordance with law. Full stop. It is made clear that if the payment is not made within 4 weeks from today, the right of the petitioners will be extinguished and they will not have any further claim for any shops.
Lord, just clarify, my lord, we are not applicant for any renewal. No.
Okay.
That may be
they will not have any right that you can take off.
Right. And annexure 1 be quashed, my lord. That's the order rejecting my prayer.
Yeah. Consequently, the impugned order, bracket annexure 1, is hereby quashed.
Right.
Item 68.
68, your lordships, that has become infructuous. I have filed a memo also.
All right. Memo is taken in record, disposed of as infructuous. All right.
Okay.
Item number 69.
May I please, my lord? My lord, the long and short of this matter, my lord, is like this, my lord. I have within the same registration 3 units. My lord, each unit is manufacturing something absolutely different. For example, one is a power plant. One, my lord, is manufacturing calcined alumina. Third is manufacturing aluminium. Now, my lord, when granting the refund, my lord, what the portal does is, since all these 3 are, I'm so sorry, my lord, what these 3 are engaged in are zero rated supplies. So exports or supplies to SEZ. We are having a special status that whatever is the statute uses the expression unutilized input tax credit is to be refunded.
Right.
Section 16(1) of the Integrated GST Act, my lords. Now, my lord, what happens is, for example, my lords, I am exporting or zero rating 100% of electricity, almost 99.85%. And my lord knows that in electricity generation, the coal would be used maximum, my lords. So the credit percentage which I get in electricity generation is around 13%. Now, my lord, despite the fact that I am exporting SEZ, my lord, supplying to SEZ 100%, almost 100% of the electricity, my lords, what the respondents are doing, my lords, by way of providing on the portal that I have to add the turnover of all three units. I have to add the zero rated, my lords, amount of all the three units, and then, my lords, apply the ratio rather than applying unit wise. Now, my lord, I have challenged that provision, my lords, that according to me was not strictly, my lords, one may say that I have held in several other cases that these rough ready measures, adding all the thing, taking a particular proportionate, has to be seen only when account books are not maintained. In my case, my lords, the statute mandates me under provisions of section 35 to maintain unit-wise accounts. I have maintained them. I have given complete figures in that regard. And there is no dispute from their side in the counter that I have not maintained. There is no such factual dispute, is not there at all. The difficulty is arising there, and they are admitting that unit-wise could have been taken. They are admitting that unit-wise could have been taken, but they are applying a caveat to it that then you should have taken a separate registration. To that, my lords, our very clear-cut answer is that, my lords, statute, it's one registration is on me. It is my option whether I take fully or, my lords, partly. Secondly, when I maintained complete books of accounts and I am ready to undergo the process of assessment and I am showing my accounts, then why are you wanting me to apply a rough ready measure? And then with that, my lords, what is happening is, with that, a significant proportion of the amount that has gone into the zero rating, my lords, do not get refunded to me. So in that sense, my lord, then rule becomes ultra vires, that if that way it is to be interpreted. My lords may kindly have provisions of section 16 first of the IGST Act.
So notice is not gone on it yet.
Notice? No, my lords, everything has happened. Counter, rejoinder, everything is there. My lords, these is a compilation of provision also that I have prepared, my lords.
There's no formal notice that 33278, I think.
My lord, my friend is appearing on VC, so. My lord, section 16, my lords would find on page 1 of this compilation. My lords would recall that under the constitution, interstate supplies and law relating to exports can be made only by the center. Lords, that's why that law has been made by the center in form of IGST Act, where they have granted this benefit to zero rated supplies under section 16. Section 16, my lords, is at page 1 of the IGST Act. My lords, are there? Zero rated supply means any of the following supplies of goods or services or both, namely export of goods or services or both, or supply of goods or services or both, a SEZ developer or a SEZ unit. And my lord knows that since SEZ's function is further to export, therefore they have been kept at par with exports. Now, my lords, what 3 says is, a registered person making zero rated supply shall be eligible to claim refund under either of the following options, namely, my lords, I am falling under option A. He may supply goods or services or both under bond or letter of undertaking subject to such conditions, safeguards and procedure as may be prescribed, without payment of integrated tax, and claim refund of unutilized input tax credit. My lords, may kindly mark this. This is what, my lords, I am saying, my lords. What the statute allows me is, as soon as you are making interstate supplies, which are in the nature of zero rated supplies, immediately you become eligible for grant of refund of unutilized ITC. And that, my lords, has been fixed by the statute. It cannot be disturbed by the rule also. That would ultimately, I would be, my lords, that would be my submission. And my lord, B is he may supply subject to such conditions, safeguard, etc. We may leave it, my lords. In accordance with the provisions of section 54 of the CGS Act and the rules made thereunder. Now, my lord, the provision of refund is contained in section 54 of the CGST Act, which my lord would find on the next page. Refund of tax.
Yes.
Any person claiming refund of any tax and interest, if any, paid on such tax or any other amount paid by him, may make an application before the expiry of 2 years from the relevant date in such form and manner as may be prescribed. Now, my lord, this zero-rated refund is covered under 54(3). I read from there. Subject to the provisions of subsection 10, a registered person may claim refund of any unutilized credit. My lords, here also the right is in respect of unutilized credit at the end of any tax period. So whatever is unutilized credit at the end of the tax period, I am eligible, provided that no refund of unutilized input tax credit shall be allowed in cases other than zero-rated supply. And my lords, inverted duty structure, we are not concerned. I am into zero-rated. That is not disputed that I am supplying zero-rated. Now, my lords, the respondents had, my lords, yes, my lord?
Provisos.
Yes, my lord, I read it, my lord. Provided further that no refund of unutilized input tax credit shall be allowed in cases where the goods exported out of India are subjected to export duty. This is not at all attracted, my lord. Provided also that no refund of ITC shall be allowed if the supplier of goods or services or both avails drawback in respect of central tax or claims refund of integrated tax paid on such supplies. Is also not in dispute. Now, my lords, I come straight away to rule 89 that my lords would find page number 9, my lords. That is 89 of the CGST rules.
Right.
My lords, 89 says application for refund of tax, interest, penalty, fee or any other amount. Any person except the person covered under notification issued under section 55 claiming refund of any tax, interest, penalty, fee or any other amount paid by him other than refund of integrated tax paid on goods exported out of India may file electronically, application electronically in form GST RFD 01 through the common portal, either directly or through a facility notified by the commissioner. Now, my lords, I come to 2. The application under sub rule 1 shall be accompanied by any of the following documentary evidences in annexure 1 in form GST RFD 01 as applicable to establish that a refund is due to the applicant, namely. Now, my lords, I will only show those clauses which are relevant to exports and SEZ. My lords would kindly see B. B relates, my lords, to export. A statement containing the number and date of shipping bills or bills of export and the number and the date of relevant export invoices in a case where the refund is on account of export of goods. So, my lord, this is what I have to furnish in case of export of goods. And my lords, if D, a statement containing the number and date of invoices as provided in Rule 46 along with the evidence regarding the endorsement specified in the second proviso to sub-rule 1 in the case of supply of goods made to SEZ unit or a SEZ developer. So, my lord, SEZ is covered here, my lord. This declaration, this, my lord, statement is to be given. A further declaration, my lord, is to be given for goods. Services, there are others also, because I am not concerned with services. I am going straight away to F. A declaration to the effect that tax has not been collected from SEZ unit or SEZ developer in a case where the refund is on account of supply of goods or services or both made to a special economic zone unit or a special economic zone developer. Then, my lord, deemed exports, at this moment I am not concerned. And, my lord, thereafter, inverted duty structure, I am not concerned with these. Now, my lords, comes 89.4, the formula for exports. In the case of zero-rated supply of goods or services or both without payment of tax under bond or letter of undertaking in accordance with provisions of section 16(3) of the Integrated Goods and Services Tax Act, refund of input tax credit shall be granted as per the following formula. Refund amount, my lords, equal to turnover of zero-rated supply of goods plus zero-rated supply of services. Multiply, my lords, may kindly notice this. Here comes the discrepancy, net ITC divided by adjusted total turnover. Now, my lords, what is net ITC, my lords? That, my lords, would find at serial number B on the next page. Milords would recall that 16.3 and 54 says unutilized input tax credit. They are saying net input tax. And Milords, how is it defined? Net input tax credit means input tax credit availed on inputs and input services during the relevant period, other than the input tax credit availed for which refund is claimed under sub-rule 4A or 4B or both. Therefore, Milords, 4A, 4B also I'll read. Here, Milords, I'll only pause for a moment for my lords to kindly see they are not referring to unutilized credit at all. What they are saying is that what is the credit that you are availing during that period? Milord, that's what they say. Input tax credit availed inputs and input services during the relevant period. So they have forgotten that there may be opening credits, there may be closing credits. All that, Milords, has vanished in the thin air. And Milords would notice on the previous page, Milord, A, previous page, last line. Milord, this is the restrictive covenant that they brought. Refund amount means the maximum refund that is admissible. Milord, have noticed section says unutilized. They curtail it by giving such kind of a formula. Now, Milords, and the expression used in this rule is shall. And Milords, ultimately, I will be showing to my lords that Milords case restaurants where again shall was mentioned 40% value. Milord would recall that Federation of Hotel and Restaurant. And Milords have stated that it is a rough ready measures. In appropriate cases where a person cannot show, all right, these can do, but not in other cases. Then Milords, and again, Milords, coming back to B, net ITC means input tax credit availed, etc. during the relevant period, other than input tax credit availed for which refund is claimed under sub-rule 4A or 4B or both. So, Milords, therefore, within the very same formula, I am trying to, Milords, starting to demonstrate to my lords that input tax credit, Milords, come into my register. There is a register input tax credit. From that credit, Milords, they are themselves bifurcating some amounts. 4A, 4B. Milords, may kindly see what is 4A. 4A is, Milords, at the foot of the page. In the case of supplies received on which supplier has availed the benefit of Government of India notification 48/2017, central tax dated 18th October published in Gazette of India Extraordinary, subsection 1 wide so and so dated 18 October, refund of input tax credit availed in respect of other or input services used in making zero-rated supply of goods or services or both shall be granted. Now, Milords, what is the significance of this? Milords would notice this, Milord, notification, Milords, may somewhere note only. This is a notification where, Milords, a person, a domestic, Milord, supplier can supply to the assessee, saying that since you are 100% EOU, or I am supplying against your EPCG license, or I am supplying against your advance authorization, so I will be supplying these goods without charging any tax. So, my lord, in such situation, what the statute has carved out is from the total ITC, please take out that of ITC which relates to export. So, the expression that is used is avail in respect of other inputs, because these inputs which are subject matter of this exemption are anyways exempted. So, there is no question of any credit. So, what the statute says is now don't apply any formula. Find out, for example, by way of input-output ratio, that what are the other inputs that might have gone into the manufacturing of the export product. Milord, that is what the significance is. The refund of input tax credit availed in respect of other inputs or input services used in making zero-rated supply. Let me take one example, Milords, to demonstrate what it means, Milords, as I understand it, Milords. It says if I have 100 rupees of input tax credit and I have purchased certain goods from domestic supplier against my EPCG license, then, Milords, my domestic supplier will not charge a tax, GST, because 48/2017 will allow him not to charge tax. So, Milord, the legislature says that means this 100 rupees credit that you have got, if you apply some ratio to it, then of export and total turnover, then what may happen is that the goods that you purchased apart from EPCG, that will also you benefit under export because that ratio will come into play. So, what they say is that if you have taken the benefit for exports under a specific mechanism, then for the balance inputs, please show us how much amount you used for exports. Actually, so if I am exporting, say, telephones and plastic I am purchasing under EPCG scheme or under this scheme of advance authorization, then say plastic excluded, whatever is under EPCG, balance input you show how much it went into exports. So there may be wires, there may be some computer machinery, etc. They say, show us how much goes to export. And that's what is the meaning, my lords. Refund of input tax credit availed in respect of other inputs or input services used in making zero-rated supply of goods or services or both. So they are themselves going by actuals. They are asking from the accounts, you tell us what is the amount. Likewise, my lord, would see 4B, where the person claiming refund of unutilized input tax credit on account of zero-rated supplies without payment of tax has first received supplies on suppliers availed the benefit of Government of India Ministry of Finance notification 40 of 2017 central tax rate dated 23rd October published so and so, or notification 41/2017 integrated tax published in so and so dated so and so. My lords, these two notifications, my lord, would notice were introduced, my lords, to provide benefit to the exporters who purchase the inputs and are exporting them as it is. So, my lord, what was happening was that they were first paying tax at the purchase stage and then claiming refund. So, what the government was seeing was that there is a flurry of refund claims and there is a delay in refunds. So, what the government proposed was, when you are purchasing something as it is for exports and the material is going directly to the port from that supplier, domestic supplier, let the supplier only pay 0.1%. So, my lord, what they are saying is, even in such like situations, bifurcate. Those items on which 0.1% has been applied, keep them separate, claim refund of that. And all other raw materials, please claim refund by applying input-output ratio or some other scientific method, my lord. They say that I'll show it the end, my lords. Likewise, my lords, in B, has availed the benefit of notification number 78/17 customs, dated so and so, or notification 79/17 customs, dated so and so, published in Gazette of so and so. And then, my lord, what happens? The refund of input tax credit availed in respect of inputs received under the said notifications for export of goods and input tax rate available in respect of other inputs or input services, my lords, this is important, to the extent used in making such export of goods shall be granted. So, my lords, as in my previous example, if this person has, for example, purchased telephones as it is for export at 0.1%. So, my lord, what this says is, of that 0.1%, you claim the refund because you have exported. Apart from that, for example, I have availed certain advertising agency. Then they say, you show how much advertisement would have gone into exports and how much would have gone into your domestic. Likewise, if you have taken transportation services, show how much have gone one-to-one basis, you show us from your accounts, records, documents. So, what I wish to show to my lords in these provisions is that the government is recognizing the fact that there may be varying situations. And my lord, I'll show in 5 also. This type of situation is there in the entire rule. That there may be varying situations for a manufacturer and there may be more than one situation to a manufacturer. For example, my lords, a manufacturer may be applying to SEZ, as in my case. A manufacturer may be supplying to exports, as in my case. A manufacturer may be availing benefit of these notifications which are under 4A, 4B, etc. Government has not and cannot, by way of the rule, provide an exhaustive formula-based system saying this would be the way in which you will be able to calculate, and you have to calculate because all the cases will not fall. And that's why ultimately, only after one point they have stated, please find out how much is the credit, my lords, and the expression they uses how much is the credit availed in respect of inputs and input services to the extent used in making such export of goods. To the extent. And this, my lords, has been left open. I'll show to my lords a Gujarat High Court judgment which is actually interpreted, and my lords, the revenue took a stand that please show us input-output ratio. That itself is an indicator as to how these amounts have to be calculated. So, my lords, this is broadly the scheme in which the provisions of granting refund, my lords, that operate. Now, my lord, how it is effectuated on the portal. My lords, I would like to show a form which is, my lord, GST RFD 01, which is to be filed for claiming the exemption. Just give me one moment.
No, in one of these petitions, you've challenged a circular dated 1811.
Yes, yes, my lord. My lord, that circular is because, my lord, what they say is, since you have not filed a claim electronically, therefore we will not give. My lord, several high courts have, my lord, many high courts have stated that since there is a specific rule allowing manual, How can you say that electronic only it will be taken? Likewise, my lord, what they have stated in the circular, that if you have filed for a particular period the refund claim once, you cannot file again. So even if some amount is left to be claimed, they say you cannot file. Whereas the statute says I can file within 2 years. If I have filed within 2 years, my lords, how can the circular stop me? The statute has no such provision. That's why these circulars are challenged.
And second is a refund order saying they've not refunded the entire amount due to you.
That's right, my lords. Refund amount, my lords, refund order. Actually, my lords, they have not even passed an order. They have returned. My lords, this is the first time I have seen what they have written in the order is that we have returning it to you.
So they're not passing an order.
They virtually, my lord, they have, but they have returned the claim to me. That's what they say, my lords. That's what their understanding is. If my lords would see that form,
it is equivalent to a rejection of a refund.
They're equal to rejection only, my lords. Yes, my lords. That my lord would find at annexure 2 of the petition, my lords. My lords may have the lead petition 24499 of 2020.
Correct.
Annexure 2, my lords would have. Petition.
Yes.
Yes, Lord would kindly see that this form, annexure 2, is at page number 52, my lords. There is a notification, and in this, my lords would find the form at page 54.
Yes.
My lord, the heading would be Form GST RFD 01A.
Right.
My lord, this says application for refund manual.
Correct.
So, my lord, what happened was one has to file it electronically and then give all the papers manually. That was how. My lord, that serial number notice that I have to tick which category I am filing in. My lord would see C is export of goods or services without payment of tax, accumulated ITC. So, my lord, for export, there is serial number C. Now, my lord, for SEZ, there is serial number E and F. On account of supplies made to SEZ unit / developer with the payment of tax is separate. On account of supplies made to SEZ or developer without payment of tax. Now, my lords, why I am showing this to my lords? My lords would notice that in fact, I had filed, my lords, the portal does not allow me to file one. For the same registration for these 3 units, the portal is also requiring me to separate. My lords, I have shown to my lords Rule 89 where declarations are there. Separate for SEZ, separate for exports. Likewise, my lord, the form, separate for SEZ, separate for exports. So within my same registration, I have in fact filed one application for a tax period for SEZ and one application for exports. I asked why I am showing this. I am showing this, my lord, because their claim is today they are only saying one thing against me. They are saying you could have claimed unit wise. They are accepting that there is a mistake in the formula. But what they are saying, you have not taken single registration. I am answering to that.
No, in terms of money,
yes, my lord.
In terms of the actual amount,
yes, my lord.
If you took separate refunds for each of the units, would you get anything less?
Yes, my lord. Far lesser.
Oh, I see.
If I take a single, my lords, the answer is very simple, and I am obliged to my lords for this. If my lords have prepared a table, my lords have that one written submission, my lords, I had given. If my lords have it, my lords, otherwise I have extra copies also. In fact, my lords would have this physical copy, would have my lord, help my lords.
Got it.
This, my lord, we had served to the other side. And I can give more copies if my learned friends, colleagues are here. My lords may first see, my lords, in the fact, these are undisputed facts, my lord. My learned friend.
In your cases, who's appearing?
Mr. Chimanka, my lords.
My lord, I am appearing.
All right.
They have to take separate registration and they have to file refund manually.
That's what he's saying. That's what he's saying.
Yes. My lords may kindly first have, my lords, what are the 3 units and what are they manufacturing and what are their inputs?
Right.
My lords, para 1, my lords are there, my lord?
Yes.
Yes, my lords. In my Jharsuguda unit, I have inputs of coal, coke, calcined alumina, coal tar pitch, my lords.
Yes.
Coal is one of the inputs, my lords.
Right.
Output, my lord, would see aluminum ingots, billets and rods.
Right.
And my lord, supply is exports and DTA supply. Then my lord would see Lanjigarh. Input is bauxite and coal. So one of the input is coal. Calcined alumina is my output and supply is to SEZ and DTA. Entirely different, my lord. That was export and DTA. It was aluminium ingots, etc. Here it is calcined alumina. Now, my lord, Jharsuguda power plant. Coal is input and electricity is output. Now, my lords, that I am supplying to SEZ and DTA. My lords would kindly turn over the page and see that what facts, my lord, which has led to this, my lord, challenge. And, my lords, why their formula has failed, admittedly. 7, my lords. Whereas when refund is claimed for each unit, in fact, my lords have asked me this question, my lords, para 6, my lords, to illustrate the controversy for this period, the refund granted on the basis of department stand is 238 CR and claim for each unit, the refund amount translates to 278 CR. My lords, that is approximately 15-16% extra. And why this is happening? My lords, I have given the reason. My lords would kindly see, first of all, my lords, Jharsuguda power plant, my lords, has net ITC of 192 crores, my lords.
Yes.
The third one, my lords.
Yes.
My lords would see what is the supply of that, my lords. 1708 crores is the zero rated supply. And my lords would also see what is the turnover total, 1709. So approximately, my lord, 99.95% is exported. Now, my lord would specifically see that what is the ratio of input to turnover here. My lord would see that is 11.28%. So, my lord, my input credit to output is 11+% here. Whereas, my lords, if my lord would see just Lanjigarh unit just above that,
yes,
ITC is only 15 crores as opposed to 192 in this third unit, my lord, because coal is not used in that proportion. Whereas, my lords, the supply zero rated are 655 against total of 1089. So, my lord, there are two factors that weigh against me, even though coal is being actually used in exporting, namely to the SEZ unit. But what is happening is, my lord, that higher 99.895% of coal that goes in electricity, which goes to SEZ, gets evened out, gets adjusted, gets reduced because of lower proportion of credit and lower proportion of coal usage. My lords, I must point out that this matter only pertains to coal credit, my lords, because coal is subjected to compensation cess, which credit cannot be used except in case of exports. I can get refund. Other, my lords, I don't even want to fight. I am only restricting myself to coal. So, my lords, what happens in coal is that even though 192.96 crore worth input tax credit goes into the power plant, which is almost 100% exported, this 192 crore credit, my lords, gets reduced because they add turnover of some unrelated factory, unrelated plant. And for this, my lords, I maintain separate accounts. And there is no dispute to that fact. And if there is a dispute, let their assessing authority decide that. I'll show that, my lords. Neither there is a dispute. And facts I have stated a word that separate books are maintained. And law requires me to maintain. If I'm not maintaining, my lords, anyways, I am at, my lords, legally, I'm not doing correct. So, my lords, this is the reason why this is happening. In fact, my lords, I have prepared one more computation. My lords would kindly see, again, turn to, my lords, page number, para number 1. My lords have already noticed that the second and third unit, my lords, are relatable to SEZ supplies.
Correct.
I'm supplying, whereas for it is only export. Now, my lords, what happens is, their admitted case, my lords, in the sense I have shown to my lords the form and the operation of the portal that I have to file SEZ and...
Mr. Chimanka, do you have the copy of this written submission?
Yes, I have.
Or
I have filed my counter affidavit.
No. I'm talking to you about the written submission that he has filed.
And my only submission.
No. 1 minute, Mr. Chimanka. Yes. Do you have a copy of the written submission that he has filed?
No.
My lords, in fact, my lords, this was submitted, my lords. There was a specific, my lords, I appeared and thereafter, my lords, were asked me to be filed. My lords, we have given that. And now I have, my lords. I am submitting everything from here.
I don't know. He's in some other location. That's why.
All right.
No, but he says he does not have it.
Should I immediately send it, my lord?
I think you have your WhatsApp or whatever, Mr. Chimanka.
Yes.
I'll immediately
send it to you on the WhatsApp.
I'm sending it.
All right.
I'm getting it. So, my lords, have noticed that the first one is export, only export, my lords, and DTA, and second and third are SEZ plus DTA.
Correct.
Now, my lords, as I pointed out and showed from the statute, they are requiring us to file separate claim for SEZ and DTA, even though it is under same registration.
Right.
I, my lord, made a calculation that if I only club SEZ, two units which are making supplies to SEZ, and separate out the unit which is supplying to exports, then also, my lords, the credit goes higher, my lords.
Right.
And ultimately, my lords, I ask myself why this is happening. My lords, they are not following the meat of the statute and, my lords, the intention of the statute. What, my lords, I ask myself, what is the intention of the statute? My lords, exports are meant for benefiting the country because in India, you charge taxes so that you can do the welfare. And what do welfare, my lord, the governments do? They provide employment, etc. They provide infrastructure. But, my lords, when we are exporting, we have to be competitive, and therefore the government says we don't want to export the taxes. Whatever, therefore, my lord, taxes goes into the manufacturing, production, even at, my lords, anterior stages. The government is giving even customs duty by way of drawback, my lords, I've seen in many cases. My lords, entire, my lords, the duties that have gone into, in fact, now, my lords, would be aware, my lord, they have introduced a road tax scheme. And, my lords, why they have introduced this? Because, my lords, in many cases, what is happening, electricity duty, etc., credit was not available under GST regime. So they have separately quantified. They have gone to that detail that, look, this product, electricity is used so much. And at the previous stages where electricity is generated and distributed, there is an electricity duty also. They give back that also.
Oh, I see.
It's a policy of the government.
Right.
And that's what, my lord, they say in 16. They have defined it. They have not left it to the executive to decide. All right, you provide some formula. What they are saying is, please give refund of unutilized GST. And, my lord, thereafter followed up with all this procedure. And, my lord, the heart and soul of that procedure is, please find out truthfully what is the amount that goes into export and give that benefit. If you don't give that benefit, my lord, I ask myself, what will happen? Our exports will become uncompetitive. And that's what is happening. My lord, I've seen the figures. My lord, there is a depression of 15%, which is coming into it. And, my lords, we are fiercely competing against countries which are highly, my lords, they are not only more advanced in technology, they are also opaque. For example, China, my lords, we don't know how much subsidies the government, if what is rightfully allowed under WTO, namely neutralizing the taxes which goes into the manufacture, etc. Even that is by way of some executive exercise, some formula which is being very rigidly applied. Then, my lords, it frustrates the entire purpose. And, my lords, I'm trying to demonstrate here, my lord, according to me, my lords, in my humble submission, the principle of interpretation which should apply in such like cases should not be, my lord, I should not argue that please quash Rule 89. I don't think there is genuinely, my lords, my
your problem is the application of it.
It's the application and the rigidity which they've applied, even though the rule itself shows very clearly, my lord, it is shouting at the top of its voice saying, please find out the amount relatable. And that's the entire purpose. And, my lords, for that purpose, my lords, may kindly have.
No, so we'll break for lunch.
All right.
My lord, matter taken at 3 o'clock.
Why?
Okay.
Because I think you will take at least an hour more.
Yes, ma'am.
He'll take some more time. What we might do is run through the board at 2.
Yes, ma'am.
And then keep it. So anyway, your purpose will be served. We'll run through the board and then take up this matter.
Whatever is convenient.
Yes. It'll hold up the entire
yes,
quarter.
ma'am.
All right.
Your Lordship, my question item 30. Area, Your Lordship. On the last occasion, my learned friend was asked to take instructions with regard to similar cases.
Number?
Because I had handed over to this decision.
Orders.
Yes.
You have that?
Yes. I handed over.
Here you have it. But that file is gone. But you hand over this to him.
Yes.
So we've recorded all this. We've recorded the fact that.
And liberty given to for considering the representation in those two matters.
Okay.
This is of 2021 one order, Your Lordship.
And the second
till date is not been implemented.
All right. You see, just show us those orders. No, take this. In two similar matters, orders have been passed considering petitioners' representations. seeking similar relief of establishment of the office of the Western Orissa Development Council in Western Orissa itself. Full stop. Those orders are dated 3rd August 2021 in Reputation Civil 21554 of 2021, bracket Himanshu Shekhar Mishra versus State of Orissa, bracket. And the order dated 7 January 2022 in Reputation Civil 7439 of 2013, bracket Darpa Ganjan Patnaik versus State of Orissa. Full stop. In the same lines, a direction is issued that the petitioners, this writ petitioner itself be treated as a representation and be, and after by the Chief Secretary Odisha, and after hearing the petition on a date which within the next 6 weeks to be intimated the petitioner at least 10 days in advance, and after eliciting use of the chairperson WODC, a reasoned order shall be passed thereon by the Chief Secretary not later than 1st March 2023 and shall be communicated to the petitioner not later than 8 March 2023. A copy of this order be communicated forthwith to the Chief Secretary as well as Chairperson WODC for compliance. The court clarifies it has not expressed any opinion in the merits. The writ petition is disposed of in the book. Obliged to be.
Item number 70.
This matter relates to levy of interest on surcharge, my lords, after the Honorable Supreme Court's order dated 28th of October 2016, my lord. Here, your lordship would kindly turn to Annexure 1 at page 21 minutes. So this is a letter dated 16/8/2017, my lords. Lords, if your lordship would turn over the page, there your lordship would see that before, just above the tabular form, my lords, which is given, accordingly, interest due has been computed as per section 13(6) of the OST Act 1947 for the periods 1/1 to 202 to 31/3/202 minutes as follows. Now, I received this on 16/8/2017, but the payments, my lord, has been made on 4/2/2017, immediately after the Honorable Supreme Court's order. And there your lordship would appreciate in similar matters, lordships have held that since this computation itself was at a later date and my payments were earlier, my lords, interest was not be levied, my lord. My second submission would be, my lord, if your lordship would kindly turn to this column 5, my lords.
What happened? You were to file an affidavit?
No, lordship, I have filed.
They have filed an affidavit. I just
case.
I have another submission, my lords. I have another submission, lords. A payment, my lord, of 1,80,000 was made during the pendency of the second appeal, my lords. What has happened, my lord, if your lordship would kindly give me a minute's time, my lords. Here, my lords, the total demand was 7,29,789, my lords. Out of which, my lords, I paid during the pendency of the first appeal 3,70,000, my lords. And that was, my lord, taken note of in the first column, column number 5, my lord. That's 3,70,000, my lords. Then, my lords, I went up, the first appeal went up against me. I went up in second appeal, my lords. During the second appeal, my lords, I paid a further sum of 1,80,000, my lords. But unfortunately, they, my lord, calculate interest on the total remaining amount of 3,59,787, my lord, without deducting this 1,80,000, my lords. This 1,80,000 payment will be evident, my lords, from the counter affidavit at page 10, my lord. If your lordship would kindly turn to page 10, my lords. This is a part of my application, paragraph B and C, my lords. Lordship has the counter, my lords?
Yes, yes.
If your lordship would kindly turn to internal page 10, my lords.
Yes, 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 yes.
Now, there your lordship would find this figure of 3,70,000 being paid on 1/5/2003, and which has been duly acknowledged in the computation order, my lords. Thereafter, my lord, I pay a further sum of 1,80,000, my lords, and the order of the additional commissioner was this has to be paid on or before 16/1/2004, and I paid this amount, my lords. Unfortunately, this 1,80,000, my lord, was not taken into account after this computation of interest, my lords, and they have levied interest on the total remaining amount of 3,59,000. So this 1,80,000, my lord, in any case has to go, my lords.
Your Lordship, so far as the levy of interest, Your Lordship, it cannot be at par with the other cases, what Your Lordship has been decided. Your Lordship, why Your Lordship might have remembered, so far as this such as Bajaj Auto case, Your Lordship, in 4 to 5 appellants, Your Lordship, state has gone to Honorable Supreme Court, Your Lordship, because this Honorable High Court has passed the order. And after disposal of the Honorable Supreme Court, during pendency, all along during the pendency after High Court, before Honorable Supreme Court, government has not taken any remedy. So what has been allowed by the first appeal or second appeal, Your Lordship, hence, after 2016, after disposal of that SLP, and department has issued recomputation order, Your Lordship has quashed all those recomputation order and has confirmed who has been before Honorable Supreme Court. Now, Your Lordship, so far as the levy of petty tax, Your Lordship, this case, there is no recomputation order, Your Lordship. Why, Your Lordship? This case, first appeal has been disposed of, assessment has been done, first appeal has been disposed of, and during pendency of the second appeal before the Law and Tribunal, Honorable Supreme Court has passed the order in favor of the department. So, cognizing that judgment, Your Lordship, and Honorable Law and Tribunal has disposed of that appeal after disposal of the Honorable Supreme Court, and recently that order has been passed, and pursuant to that order of the tribunal, this notice has been issued for payment, Your Lordship. Hence, Section 13(6), Your Lordship, has passed one order in another case, Your Lordship. So far as that 13(6), this Sky Automobiles for this petitioner, this order is not applicable. Why, Your Lordship? Because, Your Lordship, in that case, a recomputation order has been passed, even though no remedy has taken by the department, Your Lordship. In this case, tribunal has passed the order. Basing on the tribunal's order, Your Lordship, Honorable, the two dates are important. Honorable Supreme Court has passed the order on dated 28/10/2016. Law and Tribunal has disposed of the appeal, Your Lordship, on 15/12/2016. And basing on that tribunal's order, this notice has been issued for payment of interest, Your Lordship. And he has to pay the interest as per Section 13(6) of the OST Act. He has to pay the interest along with after assessment within a period of 1 month after completion of the assessment as per Section 13(6), Your Lordship. Hence, Your Lordship, the interest is he is liable to pay the interest. Only party, so far as the computation parties ask, Your Lordship may kindly remit back the matter.
So saying that 1,80,000 is
that calculation that might be, but there might be some error. That calculation, Your Lordship may remit back. He is liable to pay the interest.
My humble submission, my lord, is Section 13(6) presupposes a notice, my lords. And this, in my humble submission, is in form of a computation order, which I've just shown your lordships at page 22, my lords, of the brief. Now, this recomputation order, computation order, my lord, comes in 16/8/2017.
Not computation order.
That is the language. That is the language used.
No.
They say accordingly, interest due has been computed as per Section 13(6) of the OST Act 1947 for the period so and so to so and so as follows. So I take this to be a computation order, my lords, and my payments are much prior to this computation order, that is on 4/2/2017, my lords, and that has been also reflected, my lord, at column 5 at page 22 in the table itself. If your lordship would kindly see, the entire payment was made on 4/2/2017. And this computation order, my lord, is of 16/8/2017, my lords. So if 13(6) envisages, my lord, a notice, meaning thereby a computation, my lords, it's not an automatic thing, my lords.
No.
And after the notice, if I do not pay within 30 days, my lord, I'm liable for interest.
No, once assessment has been completed on 5th August 2002, and there the assessment order, inclusive of a demand notice, and in that demand notice, it has been stated that you have to pay this much of amount within a period of 30 days. That is the notice itself. And your lordship, that is the notice section. The provision is very clear, your lordship.
May I place 13(6) for a moment, my lords, if your lordship would kindly permit me, my lords.
All right.
13(6) of the OST Act, my lords. Section 13, subsection 6 minutes.
Yes.
In case a dealer makes default in payment of any amount for the payment of which a notice has been issued under subsection 4 by the date of expiry of the period allowed under the subsection, he shall pay interest on the said amount at the rate of 10% per annum from the said date. So it envisages a notice, my lords, and a notice under section, my lords, 13(4), my lords. And if your lordship would kindly see 13(4), my lords, it says, my lord, it gives several contingencies till F. Shall be paid. May I just please?
Yes, yes.
Shall be paid by the dealer or person, as the case may be, into the government treasury within 30 days from the date of service of notice issued by the commissioner for the purpose. So a notice has to come, my lords.
No, this, like he says, the end of the assessment order, there is this line that says you have to pay interest.
No, that particular notice, my lord, unfortunately, my lord, what has happened, my lord, now if the matter travels in first appeal and second appeal, my lords, it will await the result of the second appeal, my lords. And the second appeal gets disposed of, my lord, on 15/12/2016, my lords. Thereafter, my lord, pursuant to this second appeal order, my lord, they give me a computation order, and that is at Annexure 1, my lord, dated 16/8/2017. My payments are much, much prior, my lord, to that particular letter of 16/8/2017. That is on 4/2/2017. Your lordship may just consider the date, my lord. And
Right now, we should just send it back for recomputation of the interest, taking into account the 1,80,000 that you have paid.
Well, then let him also consider, my lord, whether at all, my lord's payment has to payment of interest is at all leviable or not. Let him consider again, my lords, in view of my submissions. And your lordship's by order.
Anyway, if it's going back, let him consider it.
Let him consider that aspect also, my lords. And pursuant to your lordship's order dated 9/9/2021, my lords, I've already deposited 50%, my lords. Your lordship may kindly note it, my lords.
Okay. The challenge in the present petition is to an order dated 16th August 2017, passed by the Deputy Commissioner of Sales Tax, Cuttack 2 Circle, Cuttack. Upholding the demand for interest under Section 13(6) of the Orissa Sales Tax Act, 1947, OST Act, relating to the period 1st January 2002 to 31st March 2002. Full stop. By the said order, the petitioner was asked to pay interest amount of rupees 536,189 within 7 days. Full stop. Challenge has also been laid to the revisional order dated 7th April 2021, upholding the above order. The revisional order of the Additional Commissioner of Sales Tax, Cuttack 2, upholding the above order. Paragraph. While directing notice to issue the present petition on 9th September 2021, the court had required the petitioner paying the opposite parties 50% of the demanded amount in terms of the impugned order dated 16th August 2017 of the DCST within a period of 4 weeks, subject to which there was to be a stay of the recovery of the balance amount. Paragraph. Mr. R.P. Curry, learned counsel appearing for the petitioner, confirms that the above order, interim order of this court, has been complied with by the petitioner by paying 50% of the demanded amount to the department. Paragraph. One of the points of contention is the manner of computation of the amount on which interest is payable by the petitioner. We'll stop. Of course, the second question that the petitioner has posed is whether at all interest would be payable by the petitioner. Paragraph. As far as the contention that the petitioner already paid certain amounts even before the order dated 16/8/2017. It appears that those have not been taken note of in either the order, the DCST or the revisional order. In particular, Mr. Kara pointed out how the petitioner had in fact made payment of rupees 1,80,000
during the second appeal.
During the pendency of the second appeal.
Pursuant to the orders of the additional.
On which date?
No, I do
Which
not
page
have the
is that?
date, but it is before 16/1/2004. That was the deadline.
No, which is the page where you've set it out?
No, page 10, my lords.
Internal page 10.
Internal page 10 of the counter affidavit. Paragraph C, my lords.
On or before 16 January 2004. But this amount was not taken into account while computing the interest payable. Paragraph. Having heard and consulted the parties, the court is of the view that the issue of levy of interest itself will be required to be revisited by the department in the facts and circumstances set out by the petitioner, the present petition. Accordingly, while setting aside the impugn order 16th August 2017 and the consequential revision order dated 7th April 2021, the court remits the matter to the DCST for recomputation, for redetermining whether at all any interest is payable, and if payable, the amount on which interest should be paid. Paragraph. The matter will now be listed with the DCST on 1st February 2023, on which date the petitioner will remain present through an authorized representative. So after hearing the petitioner, the DCST will pass a fresh order, specifically dealing with the above two issues pointed out in this order. Stop. The court clarifies it has not expressed any view on the merits of the two issues, as pointed out in this court. The petition is disposed of in the above terms.
Some time limit to complete the.
The fresh order will be passed with the DCST within a period of 3 months thereafter.
But if the petitioner may submit the proof of payment details.
Yeah, obviously.
Yes.
Otherwise, I don't get it. Obliged.
Item 71.
71 counter is not filed by Illinois Council.
Let's say 4 weeks time.
Reply be filed within 4 weeks. The last chance. It's joined up for the next date. List on. April 19th.
Item 72.
72 and 76, my lord, covered out of my lord TCS matter that.
The dates have to change, no?
My lord, yes.
Dates have to be changed.
Yeah, dates have to be changed.
So who will do all that, sir? You have to do it. Do it and give it across.
72 and 76.
72 and 76.
Yes.
All right. Change. 73.
But 73, 77, I'll provide. I've corrected. I've provided.
75 and 77.
Three matters I'm providing. I've corrected.
All right.
Item 74.
But 74, my lord, I've challenged the demand notice for shortfall of MGQ, my lord, 2014 and 15. My lord, I will approach the commissioner.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the commissioner for the relief prayed for. If such application is filed not later than 1st February 2023, then it shall be decided after hearing the petitioner within a period of 3 months thereafter.
The interim order is there, and let me continue.
The interim, till such time, the interim order passed with this court
on 10/4/2015.
10/4/2015 shall continue.
Bless you.
Item 78.
On item 70, it is a covered matter. Right. I've corrected the dates. There are two items. I've corrected the dates. In the space period.
All right. All right. Public. Item 79.
79, but I am appearing for opposite party.
All right, none appears the petition dismissed.
But the relief has already been granted. So not pressed.
Counsel, the petitioner states that he's not pressing for the petition since relief has already been granted. Dismissed is not pressed.
In this case, I am appearing for the state pollution control.
All right.
Item 81.
But 81, kindly see the order dated 26/10/2020-21. Already your lordship last directed to state to file counter. They have not filed counter yet. The matter relating to extension of lottery date, last date of lottery.
But in fact, after the extension was granted, people have participated, shops have been settled, and now they are operating. And only 2 months left for over of this period of 22-23.
But kindly see the order dated 26/10/2020.
That I don't dispute.
I was the sole applicant.
So
virtually they've made it infructuous now.
Yes.
No, my lord.
By not filing a reply. No, what you say is right. You brought this to the court in 2021 itself, 26/10/2021, more than a year ago.
The license period was granted for 5 years, my lord.
But that period is coming to an end, he says.
No, not 5 years is not coming to end. After the settlement by the lottery lords, the period for 22-23 will be over.
More 3 years
20.
is left.
No, but if it's a 5-year license,
then lordship may say that I can file a counter affidavit.
That we've already given you time, sir. Last 1 year ago, last opportunity to the opposite parties to file a reply within 4 weeks, rejoined for the next date. This IA 13966 of 2021, the interim order passed on 26/10/2021 is made absolute. That's only that will be subject to the outcome. The application is disposed of. List on. April 19th.
Item number 82.
Let's pass it over. Somebody should be there.
Item number 83.
May please, Lordship. But here the petitioner challenges the annexer 1. Here, my lord, the government has cancelled the Chitrada Maple offshore license, but without assigning any reason, my lord, and without issuing the so-called notice by the, as required under section 47(4). But it says that the license granting authority should give the so-called notice, 7 days notice. Here, my lord, so-called notice has been issued by the collector and who doesn't have the jurisdiction and authority, my lord. And my lord, I'm also relying on lordship's judgment is there. Here, lordships have, that is AFR also in Pradyumna Kumar Mahapatra's case.
But same, no counter filed here also.
Not here, the file.
No,
counter resender, everything has been filed. Counter resender filed. No.
Everything.
Counter filed. Rejoined is not here.
Yes, my lord, I filed. I filed on 30th August, my lord.
Anyway, that's
October, sorry, 31st
what's
October.
the stand in the counter?
Counter there, my lord, coming forward that there is dilution and adulteration, which is not in the fact.
No, that is not.
That is the chemical examination report says there is some less strength is there. Nowhere it is stated the chemical examination report with regard to adulteration or any noxious substance has been mixture.
The question, sole question is whether the state government has not cancelled the license. Who is the license granting authority? His stand is that the state government, who is the license granting authority, has to issue a notice prior to cancellation. My submission is that the authorities who has granted the license, that the collector he has issued a notice, so-called notice, he has replied to it, and the collector has forwarded his everything to the state government, and the state government has taken a decision. So compliance of section 47(4) has been done. Not that he has not been granted an opportunity of hearing and so-called.
No. Hearing is for the purpose of what is happening now.
Now they have cancelled the license and the stocks with them.
Cancelled by the
And
license
stocks are
granting
under
authority.
the lock and key.
That is state government.
Huge stocks are there in the lock and key from long since. Now, here my point is the collector has issued 249 under rule 249, which says about the molasses. Here it is not a molasses, my lord. Here is a IMFL off-shop. That says with regard to molasses, they have issued notice on 249. And thereafter, after receipt of chemical agency report, commissioner issued show cause notice. Well, the law doesn't say that commissioner will show cause notice. Apart from that, my lord, I have submitted my explanation. I have stated that with regard to chemical agency report, there is nowhere it is stated about the adulteration. Lordship kind of glance.
It will also kindly come to section 47, Lords.
At page
the language says, Lords, subject to such restrictions as may be prescribed, the authority granting any exclusive privilege, license, permit or pass under this act may cancel or suspend it irrespective of the period to which the same relates, Lords.
No, but there has to be natural justice.
Yes, Lord, the natural procedure has been followed.
Covered by judgment of this.
His case is that the state government should have issued the show cause notice, to which he replied instead of the commissioner, Lords. Commissioner issued a show cause notice. He showed his cause. It was considered. Thereafter, his license has been cancelled. Not that no show cause notice was issued ever, or he has not shown his cause, Lords.
Law doesn't contemplate that the commissioner will issue show cause notice.
But you have replied to it anyway.
Not I have replied. But not here the government has cancelled the license. One authority will here and another authority will decide, my lord. The authority, if commissioner is as per show cause notice, he is to decide. He has not decided. Here the government has decided for cancellation.
What do you say to that? Because the revisional authority for the commissioner's order is the government.
Yes, my lord, revisable.
Yes, my lord.
What happens? Instead of
under section
passing
6.
the order, the government is passing the order.
No, it's not revisable. Don't mislead.
Yes,
it's not revisable.
A lot of cases are directed.
Please.
Understand?
Your commissioner has not passed the order of cancellation of license, Lords. It has been passed by the state government, so no revision or anything lies, Lords.
But how? 1 minute. How can the state government pass the order when the show cause notice is issued by the
commissioner?
And all the materials will be forwarded to the state government.
It's not the same thing, sir. Who passes the order is crucial. These are all quasi-judicial authorities.
Right. And the law postulates that
the person who issued the notice, the person who heard, has to be the person who passes the order.
He has given notice of hearing, commissioner.
That's very basic, sir. But that's very basic.
But here it doesn't stipulate that state government should issue a notice. But
yes,
no. Other way around, sir. If the commissioner has issued the notice, as in this case,
yes,
the commissioner should, after hearing, pass the order. Can't be that some other authority will pass. He may be part of the government, but in this act, he is in a hierarchical position vis-a-vis the government. His order can be revised with the secretary.
Section 6, Lord. Section 6. Yes, ma'am.
So if the commissioner passes an order, then
it's like trial court will hear the case, High Court will decide.
Yes, no, that's
then
this has happened here.
That's too basic, sir.
And also, my lord, that apart, this all local High Court judgment is there. I have cited, my lord. It has been held that collector and commissioner has no jurisdiction. Only the government has the authority to, with regard to cancellation of license, show cause will be issued by the government. Your lordships have held also. In the Pradyumna Kumar Mahapatra's case, with regard to cancellation, lordship set aside their order.
Agreed by the cancellation of his off-shop license by the at Chitrada by the impugned letter dated 19th July 2022, issued by the Undersecretary in the Excise Department, Government of Odisha. The petitioners preferred the present petition. Paragraph. While issuing notice to the pursuant to the notice issued on 10th August 2022, in the present petition, a reply has been filed by the opposite parties. It is stated inter alia that under section 47 bracket 4 of the Orissa Excise Act 2008 bracket OE Act bracket, the petitioner was issued show cause notice by the Collector Mayurbhanch and then the Excise Commissioner of Orissa. Full stop. Thereafter, the government and the Excise Department is pleased to cancel the IMFL off-shop license by the impugned order. Full stop. Paragraph. When specifically asked how, when the commissioner issued the notice, the government could have passed the order. The reply given was that by the Council for the State was that the order passed by the commissioner was forwarded to the government and then issued with its paragraph, as pointed out by the counsel to the petitioner. The power to cancel the license is only with the government and not with the commissioner. To stop in the present case, show cause notice prior to cancellation of such license ought to have been issued by the government. Full stop. With the show cause notice having been issued by the commissioner, who did not have the power to issue the license, with the hearing having been given by the commissioner, it is inconceivable that he will not pass the order and the state government will pass such an order. Paragraph. Since there is obvious non-compliance with the principles of natural justice as far as the government cancelling the petitioner's license is concerned, this court has no hesitation in setting aside the impugned order dated 19th July 2022. Full stop. During the pendency, you've deposited some 2,45,900.
Miller, but that deposited and I have stocks also. They have kept it seal under seal. About 30 lakhs about stock.
The sealing of the IMFL off shop will therefore now get lifted. So the court notes that according to the petitioner, he has already deposited 4 months advance license fee. Paragraph. As a result of today's order, the petitioner should be permitted to operate his IMFL off shop forthwith.
Obliged.
Lords, may I pray one thing? Lords, may grant us Lords liberty to Lords issue so-called notice by the appropriate authority.
Nobody can stop you.
No, also observe that, otherwise they will again come that.
No, in fact, we have said that only the state government should have issued the show cause notice. Nobody else.
Only one line.
That is an implicit. No, we have said that. Commissioner could not have issued, only the state government should have issued.
One line, if you also says that state government may proceed in accordance with law, that may not.
That is not necessary. Yes, sir.
What is this?
No, there's no need to multiply litigation like that, sir. Yeah. Yeah.
Obliged.
No, call it out. We don't know what.
Item number 84.
May I please, my lords? Your lordship, lords, by order dated 18/5/2022, was pleased to formulate few questions for adjudication.
Right.
So one is whether the activity of photography constitutes works contract involving deemed sale of goods under the Orissa Sales Tax Act 1947, or the same constitutes a contract of work and labor. Two, whether in the facts and circumstances of the case, the order passed by the Orissa Sales Tax Tribunal holding the photography business constitutes the works contract can be sustained in law in view of judgment of this court in the case of Sujata Studio versus Commission of Sales Tax, reported in 106/2008 CLT 317. So, two questions are there.
Yes.
Plus, I have given to Lordship Lords a compilation of judgments, Lords.
Right.
This issue, Lords, has been addressed by different high courts, including Apex Court, on both counts. Both counts, what I mean to submit to Lordship Lords. That's what is essential the nature of activity involved. Precisely one sentence, as laid down by the learning tribunal, that what I do is, I process photographic rolls into negatives and print the positive from the negatives by using materials like photographic printing papers, chemicals, and I supply the positives and negatives to customers. Essentially, this is the business activity. So, whenever
the role is given to me, two things. Either some give me roles to prepare negative and positive prints, but ultimately their interest is to get a photograph. Because in order to prepare photograph, the photographer needs paper and chemicals. Because this has been minutely examined by each and every court in so many judgments, Millards. And two counts, let me clarify on this saying, that there was dispute both as regards to imposition of sales tax as well as service tax in respect of same activity, one imposed by the central government and other by the state government. And one is under entry 84, the other entry tax, residual entry, residual entry, so far as service tax is concerned, and this is entry 54 Millards. Now, again, Millards, the question arises, as your lordship have formulated here, Millards, whether it's a works contract or it's a contract of Millards, service and labor. But the question is, if this will be works contract, then further question arises whether the material involved for preparation of prints, photographs, which is taken delivery by the customers, involving this paper and chemicals, does at all constitute subject matter of levy of tax under this concept of works contract within the envelope entry 54 leads to 7th schedule Millards. Now,
Sujata, what does that say?
Yes, Sujata says, Sujata Photo Studio judgment of this Honorable Court came in 2008, which is post Rainbow Color Laboratory. But before I take your lordship's attention to Sujata Millards, in Rainbow Color Laboratory's case, Honorable Apex Court said that Millards, even if this is termed as works contract, but the dominant objective is it's the photograph, not Millards the negative or positive print, or it has no commercial value. Millards, my photograph, when I go and take my photograph in the studio and take the positive prints, it has Millards value utility for me. It has no utility for others, Millards. Unlike photograph of great leaders like Subhash Chandra Bose, Mahatma Gandhi, or some film heroines, those photographs are sold as commercial goods. Positive prints, glossy paper, those are sold in market. That may have commercial value. But whenever a customer, Millards, approaches a studio to take his photograph and get the prints, it has for him, it doesn't have utility for any other Millards. In the similar way, I will also take your lordship's attention to Everest Xerox matter papers case, Millards. Suppose in Xerox, Millards, Honorable Apex Court said, whenever we get Xerox copies of the document, we intend to have the Xerox copy, but it has utility to me. The Xerox printout has no value for any other person than the person who approaches to get Xerox copy. So therefore, Honorable Apex Court in Everest paper case, it cannot be said to be works contract, even if paper is used. But essentially, the Xerox copier, the person operating Xerox Millards, he is Millards essentially giving me the printout of the document which I want to copy on a piece of paper. So paper may in the process is used for delivering the printout, Millards. But that is not the essence, because Honorable Supreme Court said no, it cannot be Millards subject matter of levy of tax, because it has no utility for anybody else. It has utility for him only. And therefore, it cannot be subject matter of tax, Millards. And it involves work and labor and service. It cannot be subject matter levy of tax under works contract. Now, in BC Campbell's case, Honorable Apex Court said, but I will not burden your lordship just going through all the judgments saying that, but the art of photography, Honorable Apex Court has very vividly examined, saying that it involves a skill, Millards, subjective skill and artisan Millards skill, which is with the person who prepares the photograph. Millards, a black complexion person, whenever he gets photograph, Millards, it may he will look very Millards beautiful, handsome, and with good. His color cannot be made known from the photograph.
No, but why do you say that a dark-skinned person is not beautiful?
Sorry, my lord. Because that is how the skill of the photographer, he prepares the photo in such a manner that even Millards person may not look. So the whole emphasis of the Honorable Apex Court, while saying so, is that it involves a kind of skill, Millards, in case of photography. Therefore, when question arose, whether it can be a case of works contract involving this use of paper and chemicals for preparation of fugitive prints to be subject to levy of tax, or it is a matter of contract for labor and service. Honorable Apex Court said no, it's a matter of labor and service. It cannot be said to be a case of. Plus that BC Kame's case way back in 97. Plus thereafter came this rainbow color laboratory. Rainbow color laboratory case, Honorable Apex Court said no, it is benefit objective. Suppose something passes incidentally, which is not intended to by the parties. That's like the case of photography. But my interest is in a good photograph mirrors. But in the process, I get a piece of paper. In the process, mirrors, the chemical used gets subsumed. It becomes extinct while giving me the positive print. So I don't have any intention of what is being given to me. I am only interested in good photograph mirrors. So
Rainbow Color Lab is reviewed.
Sorry?
Rainbow Color Lab is reviewed.
That's what I'm saying. Rainbow Color Lab case, that was examined in the case of ACC Limited. I am just telling your Lordship, right? ACC case. ACC Limited case, Honorable Apex Court doubted the
correctness of rainbow.
Yes, rainbow. Saying that dominant objective cannot be a good reason not to levy tax. Even the involvement of this goods may be least, may not be substantial, but it can be subject matter of tax. Now, in JK, I have given all compilations, so I am summarizing. Let's see this JK, CK GDS case. CK GDS case, Honorable Apex Court again came across saying that the observation and actually the Apex Court in SEC case, doubting Rainbow Color Lab is not a fact. It's a passing observation. So it cannot be said that Supreme Court has overruled Rainbow Color Laboratory. That is what CKG does say. Again, this matter went to Honorable Apex Court in the case of subsequent judgment of LNT. In the LNT case, Honorable Supreme Court clarified, giving a very clear picture to everybody that the observation and findings with regard to this in Rainbow Color Laboratories case is overruled by SEC. So in view of the succeeding judgment of the Honorable Apex Court in case of LNT, now we have to have a conclusion that Rainbow doesn't survive, and so also this CKG also doesn't survive. Now, I am not on that. My humble submission is, after Rainbow, the Sujata case was delivered by your Lordship, the bench of this Honorable in 2008. Now, your Lordship may kindly see, that is the question your Lordship formulated. In my compilation, my Lordship may kindly see Sujata's case. It starts from page 67. And the question which your Lordship have formulated is paragraph 2 minutes. Page 68, running page 68 of the compilation, serial number 1, whether on the facts and circumstances.
1 minute.
Question number 1.
The OLR reporting 954.
Studio Sujata.
Minus. That's paragraph 2, question number 1. Questions are whether on the facts and circumstances case, the tribunal is right to held that tax is exigible for photographs as execution of works contract. And whether on the facts and circumstances case, the conclusion of tribunal is perverse due to constitution of facts and law, therefore no liability set aside. 3. The material fact is same as this. Yes, same as this. Now, your Lordship may kindly turn to us. Paragraph 9, 10, 11. Paragraph 9 deals with self-tax subsidy versus BC Kame, which I just told to Lordship. Saying that the photographer takes the photograph. I am reading from page 70. Yes. Takes photograph, develops the negatives and does other photographic work, and thereafter supplies the prints to his clients. By doing so, he cannot be said to enter into a contract for sale of goods. On the other hand, the contract is use of skill and labor by the photographer to bring about the desired result. And judges held that the job of a photographer is a contract for work and labor, and it's not a contract of sale. Now, Photo Emporium case also followed by BC Kama's case judgment followed, and it was held that it's a case of contract of work and labor. Then photo color lab also. These are all high judgment of our High Court belongs. 110 is for 145. This is also. Then Studio Kamala Alaya versus Commercial Tax Officer. That was also referred to following BC Kame. They also. Now, paragraph 13, Karnataka High Court. The same principle in the case of Keswaram reported in 121. In that judgment, and judges could rely on the judgment of Supreme BC Kame's case. BC Kame is followed, saying that it's not marketable commodity, so therefore it cannot be held to be a case of worse contract. Now, your Lordship may kindly see the finding, my lords. That is, 19, paragraph 19. For the reason discussed above, we answer the first question negative. That is enough. So this is in favor of assessee and against the department. This is how Sujata deals with the issue, my lords. Now, Everest copier, which I was telling your Lordship, my lords, your Lordship may kindly turn to, my lords. It's page 63. It's a small judgment, page 63, my lords. Yes, my lords. Your Lordship may kindly see the first paragraph 1. I'm skipping 4 lines. The question that we are concerned with, therefore, is whether the making of photostat copies with the use of Xerox or other machine and delivering the copies so taken to the customer on receipt of payment of amount to a sale of goods exigible tax under Tamil Nadu General Sales Tax Act 1959. And this has been dealt in paragraph 7. Only one paragraph will suffice. As we see it, in running page 60.
Right. The view taken by the
as you see it. The view taken by Karnataka High Court is right and is based upon the decision of this court, where the main object of the work undertaken by the person to whom the price is paid is not the transfer of a chattel as a chattel. The contract is one of work and labor. The main object of the work undertaken by the operator of the photocopier or Xerox machine is not a
is excluded. Authority to apply all these laws and redetermine the whole issue. Because after the assessing authority's order, all this case law has come. What percentage of goods has been transferred? Title in such small quantity, has it passed on?
Actually,
who's going to determine all that?
Actually, the basic difference in between all the judgments and
because in the trial balance or something will have to be looked into to determine what is the
basic difference in between all the judgments and the petitioner's case is that in the case of Sujata also, they are the photographer. They are themselves photographer and they have clicked the photo.
But even in a photo studio, invariably somebody is sitting and you click only.
But here,
Sujata is a photo studio.
In this case, it is not a photo studio. It is a lab. It is a laboratory. That is the difference.
So what a lab does, a studio does eventually the same.
Your Lordship, in that case,
even in a photo studio, you will have freelance photographers come and deliver the photo rolls.
Only those photos.
So photo studio also does the same thing as a photo lab. Lab and studio and all are used interchangeably in the commercial, in the marketplace. Let it go back. Yeah, time that, correct. Correct. Yeah. The present revision petition arises from an order dated 31st July 2007 passed by the Orissa Sales Tax Tribunal, Cuttack Tribunal, dismissing the petitioner assessee's essay number 604 of /2002-03, which in turn questioned an order dated 30th May 2002 passed by the Assistant Commissioner of Sales Tax, Cuttack 1 Range (ACST), affirming the extra demand raised by the sales tax officer, bracket STO, by the assessment order dated 31st January 2001 for the year 1999-2000. Paragraph. While admitting the present revision petition on 18th May 2022, the following two questions were framed with this court for consideration. Reproduce the two questions. Paragraph. On the first issue, there has been no full stop. Paragraph. On behalf of the petitioner, Mr. Jagabandhu Sahu, placed extensive reliance on the judgment of this court in Messrs. Studio Sujata versus Commission of Sales Tax 106 2008 CLT 317, where the activity of developing positives from negatives in a photo studio was held not to involve any element of sale. Full stop. The decision in Studio Sujata Supra was itself not available to the assessing authority when the original assessment was framed in the present case. Stop. Thereafter, there's been a further development of the law with the Supreme Court in the L&T case, right?
Minors.
As this was clearly an erroneous approach to deal with the issue, and the judgment of High Court is clearly ununderstandable. The High Court did not even deal with the various cases issued correct perspective in the light of the subsequent judgment prolab.
There have been subsequent development. No, L&T and then prolab, right?
L&T and
So I'm still on L&T now. 1 minute.
this just dealt with cone level. After L&T, I just built such cone level.
Okay.
So that is also taken in prolab.
Oh,
So now,
okay, there have been subsequent. Yeah, there have been subsequent developments in the area. Including Larsen and Toubro was the state of Karnataka, 2014 1 SEC 708, which was again discussed in state of Karnataka versus ProLab, AIR 2015 SC 1018. Paragraph.
Prolab might not relate to service tax issues, you know. Deals with photography, but they are dealing with service tax issues.
Right.
Yeah.
That case, Larsen and Toubro case was again dealt with by 5 judges constitution bench in cone elevator. That was referred to in ProLab. That is why.
Correct. Yes, cone. Yes, correct.
The court is of the view that the entire issue requires to be revisited in light of the judgments of the Supreme Court referred to here and before, apart from permission of this court in Studio Sujata Supra. Paragraph. Consequently, while setting aside the order of the tribunal and the corresponding orders of the SCST and STU, this court remands the matter to the state tax officer.
Sales tax officer.
No, now it will be state tax.
Now it is yes.
State tax officer. Cuttack 1 Central Circle for redetermination of the issue for the year 1999-2000. So the matter will now be listed before the STO, State Tax Officer, on 1st February 2023, on which date the patent present through an authorized representative. The second one is the same, is it?
So all others same subject, but period different and company different. More or less same, my lords. Questions are same.
Yeah. So similar order will have to be separately typed out for that Zoom color. All right. The petitions are disposed. All right.
Deeply obliged.
Supplementary list pastoral matter item number 61.
So other matters, the kind of memo which I have given your lordship formal question, such a memo is not there in other petitions, but questions are same. Issues are same, but question is not given in this way.
No. So what is it? You have to list it first, or no? It's not on the list today.
The way, Millers, I have given the memo, Millers, your lordship formulated question, Millers. Because this question is formulated in this case, Millers.
Right.
Other cases are identical, but this kind of question is not framed in all matters.
No. The other cases are not on board today, no?
No. Others are there.
Zoom. Oh, the other case you mean? I thought you said cases.
All connected matters are also there. Today, Millers.
How many cases are there? I only saw 2. No, but he's saying there are other cases. From Kalinga.
I've not seen that Zoom 16. Zoom 16 color and Zoom 16. All are Zoom 16 color.
There are only 2 cases.
Millers, STREB 112 of 2008, 113, 14,
what item number?
84.
Mr. Sahu, you mean to say that in Zoom 16 cases, identical questions were not framed. So these questions will be.
Correct. That will also apply to all, Millers.
Kalinga's questions which are framed.
Yes.
Kalinga, that will abide.
Yes.
So in STREB 112 onwards, we have to frame questions like this.
Yes.
Reframe.
No questions have been framed, he says.
No.
So we'll have to admit following questions are framed. And then you simply say, in light of the order passed today, in the first one, this is also sent back.
Your lordship have seen the memo. In the memo, your lordship have substituted in place of rainbow Sujata color lab. So in all cases also like this, rainbow color lab is mentioned and your lordship have substituted to Sujata color.
Yeah. So we'll anyway formulate those.
Yes. Accordingly formulate. Obliged.
All right.
In item 61 with the lordship permission, I am filing the small brief today. A copy to my grandson and appearing for the state.
So we'll take it up on some other day. Mr. Samir Mishra states that he is filing rejoinder during the course of the day.
May I pray, my lord, maybe early part of January, if your lordship pleases.
This is a river ferrying lease, is it?
The embankment and the 500 acres of agriculture and all those things are there. I'm praying for early January, if your lordship pleases, maybe fixed.
I think the earliest will be 24th or 31st January. All right.
Grateful, my lord. Grateful, my lord.
That's 24th then.
31st January.
31st.
Grateful, my lord.
Pastoral matter item number 82.
On behalf of senior advocate P.K. Mahanti, my lord, I pray for short and adjournment.
All right. Counsel for the senior counsel for the petitioner in some difficulty today. What's the matter about?
My lord. And my lord, as per order dated 28/6/2022, state may file the reply, my lord. In the meantime, in IA.
That is, I have already filed matters. On 15th of July, I have filed matters.
Copy.
Copy agreed. Copy has already been served, my lords. I have already filed the counter affidavit.
March reply we have. Look, following questions. No, after that we don't have reply. You filed it on 15 July.
Yes, in fact, in March, the lordship directed me to file a soft copy, but somehow the original copy was misplaced, so I have subsequently filed on 15th July, my lords.
Nice. Not bookmark. You've not got a copy of this?
No.
All right. Copy of the affidavit filed by the opposite party state on 15 July 2022 be served on counsel for the petitioner. List on 27th April. Acha. So you this affidavit is dated 15 March.
Yes.
But filed on 15 July.
Right.
Oh, you probably will have the affidavit then.
Well, I'll check.
My lord, I may be pardoned to mention on behalf of Mr. Rai, item 12, 13, and 29 of the weekly list will be taken up next week.
Not finishing supplemental. Item 69 to be called.
Yeah. So it will stay on board anyway.
Item
note of the numbers.
Item 69.
My lord, I have to file a short reply of the written submission and verify the SLP has been filed before the Supreme Court or not. We have sent I have sent the judgment to the commissioner and he wants some time.
Lord, he can reply on Monday or whatever. I'll finish my arguments.
Made all his cards.
Yeah.
This otherwise, my lord. I'll not take much time, my lord.
I know, but he must be in a position to reply. That's the only thing.
Reply, they have already filed, man.
No, he must be in a position to reply to your arguments.
That's what I'm saying, my lords. May have it on Monday. He can reply on Monday. I'll come on Monday, Tuesday, Wednesday, whichever day, my lords. He'll get time also in the meanwhile.
No, if you're anywhere joining it, it's not going to get over today.
I'll finish it, my lords. Because I have argued mainly and I have given written submissions also. I have to show 3-4 judgments. One para each.
Mr. Chimanka, this is all actually on judgments on interpretation of statutes. Those are general principles. This very provision has now not been interpreted, so there's no judgment on this provision.
No, there is none, my lord. There is none.
That's what.
Yes. So, my lords, what I was submitting before my lords was that the purpose of zero rating, my lords,
right,
is that the taxes should not be exported.
Right.
Lords, has the judgment set, my lords?
I think yes.
So it is here. Sorry. While, my lords, I show the judgments, my lord, their own circular. My lords, the section paper book that I gave to my lords.
Yes, section paper book.
My lords, their own circular on the very same compensation cess, my lords. My lords would find it at page 31.
31.
Para 4. They have themselves stated what is the purpose. My lords are on page 31.
Yes.
My lord, it says further as per subsection 5 of 7 of IGST Act, supply of goods or services of both, when the supplier is located in India and place of supply is outside India, will be treated as interstate supply. Therefore, exports being interstate supplies, they will be liable to compensation cess. This, however, will not be in line with principles that no taxes be exported and exports have to be zero rated. The purpose is stated, and then para 8, they clarify, therefore give refunds to exporters. Now, my lord, they cannot give from one hand and take from another by computation formula. Likewise, my lords, may just have one paragraph of the Delhi High Court judgment, my lord, the first one that I have submitted, my lord, just now. TMA International, para 14 at page 4. In a somewhat similar situation, my lords, they were denying that since you have applied for drawback, some wrong claim has been made, therefore will not give you benefit. My lords, the lordships in the Delhi High Court, my lords, held para 14, page 4. My lords, may only notice from 5th line, I'll only read 4 lines, my lord. During the transitional period, this is how it starts. Para 4, page 14, 5th line.
Right.
During the transitional period, petitioners have inadvertently claimed benefit under a wrong provision since there was lack of clarity with respect to refund of IGST. Should we deny the benefit simply for this mistake? When the cardinal rule is that taxes should not be exported. The concept of zero rated exports envisaged under GST is designed to achieve the objective. This is the objective, my lords. There is no one's, and they themselves admit this. Now, my lords, I proceed. My lords, I have already shown to my lords section 16.1, 16.3 of IGST, my lords, which says unutilized ITC refund has to be granted. Now, my lords, what are their contentions in, my lords, the counter affidavit? They say 3 things, my lord. Number 1, my lords, they are not denying that they are granting full credit, full refund under 89. They are not saying that by formula we want to restrict. They say in para 14.2 of the counter affidavit that ITC gone into zero rated supply. The word they use is entire ITC gone into zero rated supply is being provided, my lord. So they are not denying it. They are only denying it, my lords. I'll just show those paragraphs. First, let me complete, my lords, these 3 points what they are saying. First, they are saying that ITC gone into zero rated supply is being allowed by 89. Second, they say that assessee has right to claim unit wise. They are not denying that also. The only thing that they are saying is that you should have taken separate registration for that. And what they are also admitting
so the
is
GST law requires that the petitioner either follow the unit-wise application of formula over all the refund periods.
That's right.
Or follow the group-wise application of formula.
That they agree, my lords. They agree that I have the option. That's what they are saying, my lords. I have the option. So they are not disputing this point. What they are only saying later somewhere in this paragraph is that they must have taken a separate registration. To that, I'll respond, my lords. I have responded partially. I'll respond completely, my lords. And then, my lords, in para 11.4, they also state under the formula of rule 89.4, the margin of error itself gets averaged out. So they are admitting in my facts that there is an error, but they are assuming that it will get averaged out. Whereas period after period, my lords, I am filing claims before my lords that it is not getting so. It is their assumption. So, my lord, there are 3 things they are saying. They are saying we are denying you refund. 89.4 gives you complete benefit. It is not their case that by 89.4 formula we could have denied and we have denied. That's not what they are saying. They are saying we wanted and we are giving. Second, they are saying you could have opted for unit wise. Fourth, they are admitting that there is an error, but assuming that it will get evened out. But they don't say how it get evened out. And I have given an undertaking in the rejoinder that this formula be applied month after month. I am not saying please select 3 months when I have benefit with this formula, give me this. When I am do not have the benefit, don't give me this. I'm not saying this. If there are any claims in between where I have to be given less, please do that. I am not, Milords may record that concession. We have given it in writing. So, Milords, what I am submitting is that these 3 things which they say that we are giving, Milords, the first answer to it we are giving, but I have demonstrated to my lords on facts that it is not being received. And, Milords, those facts in the writ petition are not denied. Milords may notice the facts in the writ petition are pleaded about that computation in paragraph . Lords, para 14 of the writ contains what has been granted by them. Then, my lords, the revised calculation which I am claiming is at para 15. These figures, my lord, they are nowhere disputing. And my lords, the fact that I am maintaining separate books, my lords, for each of the unit is also pleaded specifically, which they have again not denied. I'll show it to my lords where I have pleaded it. Yes, sir. Para 2. Para 2 of the writ petition. I plead that these are my 3 units. And just below that, page 4, my lords would find.
So if you are saying that you're asking for a refund for each unit separate.
That's right, my lords. I am asking for computation on input-output norms basis for a unit. As I mentioned, my lords, for example.
No, but they seem to just come to para 11.3.
Yes, my lords. Of their counter, my lords?
Yes.
Yes, my lords.
What they seem to suggest is something else. I think so. Let's see that.
My lord, yes.
In fact,
from the beginning, may I read?
11.3.
Yes, my lord. In fact, the formula of Rule 89.4 is completely based on principal equity equality, wherein any or all registered persons have been allowed refund of that percentage which belong to zero rated during a refund period. Section 25 allows petitioner to either take combined registration of all of their 3 units or take separate registration. Since the petitioner themselves have chosen to take a combined registration, all 3 units taken together qualify as a single registered person at 25, and therefore 89.4 formula has to be holistically applied to the entire group of 3 units of the petitioner in a combined manner.
No, is this correct? Since the petitioner themselves have chosen for taking a combined registration. Is that right?
It's my choice. I can take one registration.
Actually, you've taken a combined registration.
I have taken one registration. My lords, how it happens is for SEZ, I have to take separate. So my SEZ unit in Odisha has a separate registration. But these 3 which are before my lords today has a combined registration. There was, my lord, some sort of an embargo also on this, whether I could have taken or not. That part also I have pleaded, which they have not disputed. But their stand today is that since I took single registration, therefore it cannot be given.
Yeah. So just read on now.
Yes, my lords. So, however, the law enshrined in section 25 allows the petitioner to take separate registration for each of their 3 units. In that case, the formula will have to be individualistically and separately applied to each unit without having the facility of averaging, which is presently available to petitioner under combined registration. This petition is not only illegal and unconstitutional, inequitable, allowing into unjust enrichment because petitioner want to avail more refund than ITC related to zero rated supply by applying Rule 89.4 unit-wise and group-wise over the different refund periods, whichever is more beneficial to them by taking benefit of averaging of net ITC in favor of a unit with lower export ratio in one refund period and taking unified refund whenever it is more beneficial to them. That's what they are saying, that whichever is more beneficial we are taking. But that is not, we have pleaded specifically, I'll show that in the rejoinder, that we are undertaking, that we will only continue with one method. And wherever it is more, the average method is more, please, you calculate that also. We are not at all saying that please give only for those periods where it is beneficial. Otherwise, we will take on average. No, we are pleading. That's what I showed to my lords at para 2 of the writ, that we have stated we are maintaining separate books of accounts, and I'll show those 2 provisions also. Sections.
So the nub of the issue seems to be with one registration.
Yes, my lords.
Merely because you take 3, maintain separate books of our accounts for your 3 units.
Right, my lords.
Should the refund be calculated for each separate unit, or should it be combined?
Calculated. Yes, my lords. And my lords, to that, my lords, kindly also see their own at para 14.2. Where they say,
that averaging out.
They say entire amount of input credit gone. They are not saying that we are not giving entire amount. They are saying 89.4 is meant to give entire amount. It is not their case that they are saying 89.4 is meant like that only, whether it gives or it does not give. They are saying it is meant to give entire amount. And then, my lords, they say, my lords are on page 14, my lords.
Page 14 of?
Page 14 of their counter.
Right.
My lord, it says section 16.3 has loan for refund of unutilized input credit in relation to zero rated supply. Accordingly, Rule 89.4 has provided for refund of that input credit which has gone into zero rated supply. Rule 89.4 has provided without any discrimination for making good of the entire amount of input credit gone into zero rated supply as refund. This, my lords, we are saying that they are also saying that we want to give full refund, which goes into exports or zero rated. But factually, that is not happening. That's what I showed to my lords. My lords, a unit which is giving 100% almost to SEZ, but its credit refund goes to 65-70% because average, they apply average. Then, my lords, 7-8 lines below this, since it is quite possible that registered person may have multiple subunits, the refund formula may be applied holistically, combining all the subunits of a registered person. Yes, or alternatively, the same may be applied individualistically to each unit. So they again do not deny that it has to in all cases be applied like that only. That's not they are saying. They are saying both ways is possible. Of course, my lord, the objective being to give the full benefit. My lord, have found that?
Yes, yes.
Yes, my lord. Then, my lord, they say the combined reading of so-and-so provision reveal that refund is allowed only to a registered person, that also only for particular tax period of 1 month. The said provision law provides that taxpayer has an option to regularly and constantly apply for all refund either holistically, combining all their subunits, or they can individualistically apply the formula to each of their subunits. A taxpayer, and in, my lords, in this petition which is before my lords, all periods I have claimed, all periods by this formula only. In second petition also, third also, I think only for, I'll give that also, only for 2 periods, it was coming lesser, for which we have given an undertaking that we are not saying that please for those periods give me on average. I'm saying unit wise because I have accounts. Then, my lords, then they say, they are giving themselves the reasons. My lords, next page. It is also possible that due to price differential of various subunits, or differential in ratio of zero rated supply vis-a-vis net ITC, during some period, the amount of refund as per individualistic and holistic application of refund may vary into any direction. Since law allow refund only to registered person, then again, my lord, they talk about registration. A taxpayer with combined single registration cannot claim refund on basis of individualistic application, because in that case, the individual units would not qualify as registered person. Then, my lord, what they say, the restriction of application of refund formula in this manner will result into evening out of any margin of error between individualistic and holistic application. So they are admitting that there is some kind of a margin of error which is arising because of this formula. Then, my lords, they say, however, different individualistic combined are allowed to choose any of the individual formula as per their convenience. The subject margin of error will rather increase. But I am showing on facts that applying same formula period after period, my lords, is denying me the benefit. Now, to answer these in law also, my lords, I have shown to my lords the purpose of 16. I have endeavored to show also that 16 uses the expression unutilized credit. It does not use the word which they are saying net credit taken during the period in the rule, my lords. And, my lords, I have also tried to demonstrate to that once there is a purpose which is there under a statute, Lord, my submission would be that the rules must be so construed to effectuate that purpose. And this is a very important purpose. And Milords would kindly notice that, Milords, unlike an exemption notification, Milords, this 16 is not exemption. This is, Milords, zero rating. And Milord knows that zero rating is something where, Milord, exemption, Milords, recall that the input credit is not allowed against exemption. So exemptions are also tax, they suffer tax on input side. But zero rating is a specific thing only for exports because we want to boost those, and that is under section 16 statutory. Right. It is contrary to, Milord, section 6 exemptions which are given by subordinate legislation. Section 6 of IGST, government has to notify. Here, Milord, the statute itself gives zero rating. And Milord, this is under Article 286 of the Constitution, which says law relating to exports would be made only by the Parliament. And Milord, in that conspectus, what we are interpreting today is not an exemption, Milord, which is to be read against the assessee. Statute itself. Rather, it is statutory, beneficial, and export-oriented, which should be read in favor of the assessee. Right. For that, Milords would only see, Milord, I am saying...
There's enough case law on that.
Yes, Milord, I have only cited with paragraphs. Milords may see at para 22 of my note.
Yes.
Milords, B and C, Lakshmi Machine Works and HCL Technologies are on exports. Right. Milords, only to demonstrate what they said, in HCL, for example, Milord, they said if something is not included in denominator, you can't include it in numerator, otherwise it will make it absurd. Here also, Milord, what is happening is if you apply this type of a formula in this manner, it will make it absurd. And Milords would recall Gursai Saigal case where the Honorable Apex Court said that in machinery provisions, Don't apply as if it's a charge. Please effectuate the purpose. Find out what is the purpose. Purpose is to determine how much amount went into that. Determine that. He is telling you, assess it. And, my lord, there is enough authority for that also. For that, my lords would see one paragraph of my lord's own judgment. My lords, my lords, it was Federation of Hotel and Restaurant Association of India. My lords, I request my lords to take that for a moment. My lords, that my lords would find.
89.
My lords, para 61 at page 112 of the compilation of judgments. And my lord, before that, the provision my lords would find. My lord would see para 16 at page 95.
Yes.
My lords, rule 2C was there.
Yes.
Para 16. My lords are there?
Yes.
Yes, my lord. It says determination of value of service portion involved in supply of food or other article of human consumption or any drink in a restaurant or outdoor catering. The same problem, my lords, which my learned senior colleague was arguing, my lords, relating to photography. In restaurants also, my lord, part of it service tax, part of it sales tax. The statute, my lord, said, subject to 67, the value of service portion being food or article for human consumption in any manner, etc., shall be specified percentage of total amount charged. And my lord, the specified percentage, my lord, would see was 40%, my lords, on the next page.
Yes.
Now, my lords, how my lords read it after referring to the Supreme Court judgments on the very same subject, my lords, in para 61, page 112.
Yes.
Lord, the last 4 or 5 lines of para 61, it also requires.
Yes.
It also requires to be kept in mind that ready reckoner formula is useful where an assessee does not maintain accounts.
Right.
In a manner that will enable the assessing authority to clearly discern the value of service portion. My lords would recall, my lords, Gannon and Curley, when Constitution Bench was examining 366-29A,
right.
My lords, what the Constitution Bench held, my lords, that if a assessee actually maintains, please go by that books. These are all ready reckoner formulas if they do not maintain or if their books are not worthy of credence. That is not a finding and there is no dispute. Now in this light, my lords, one more latest judgment I will just pass on, my lords, which has relied upon all these aspects, my lord. My lords, I must mention what happened in this. I need not read it. My lord would recall that GST, no tax is charged on sale of land. Now, my lord, Parliament said no tax on sale of land. By delegated legislation, they said land is 1/3.
Oh.
My lord, the Gujarat High Court has recently, my lords, quashed that, saying you can't, only in cases where a assessee chooses or is unable to provide the value of land, can do it. My lord, the conclusion, my lords, would see at the end. So the conclusion is second last page, 120 para. And after considering all relevant judgments, my lord, this has been passed. And since it is in GST, that's why, my lord, I endeavored to show this to my lords. Para 120, my lords, last but one page.
Right.
And sorry, my lord, there are no page numbers. I don't know.
No,
where,
that's okay. We've got it.
In the result, the impugned paragraph 2 of notification, central tax and identical under Gujarat goods and service tax, which provide for mandatory fixed rate of deduction of 1/3 towards value of land is ultra vires the provision as well as scheme of GST Act. Application of such mandatory uniform rate of deduction is discriminatory, arbitrary and violative. While we so conclude, the question is whether the impugned paragraph 2 needs to be struck down or the same can be saved by reading it down. In our considered view, while maintaining mandatory deduction, value of land is not sustainable in cases where value of land is clearly ascertainable or where the value of construction can be derived with the aid of valuation rules. Such deduction can be permitted at the option of taxable person, particularly in cases where the value of land or undivided share of land is not ascertainable. That's what my lords had held in that service tax case, my lords federation, that if it's a ready reckoner, if he provides, then you go by. Now my lords may have section 35 for a moment that there is a statutory mandate, registration or no registration. My book. 35 1 minutes.
Yes, yeah.
The first provision.
Yes.
35 1 first proviso.
Right.
Provided that where more than one place of business specified in the certificate of registration, the accounts relating to each place of business shall be kept at such place of business. That's very, and the rule also says so, my lord.
Right.
So the accounts have to be maintained, they are being maintained. Now, my lords, they say that registration is relevant. Apart from showing that I am maintaining records, Apart from these arguments that ready reckoner is to be applied when actuals are not available. The third argument is, my lord, there is no connection between registration and grant of refund. Section 16 has no such thing. It only says whatever is unutilized and that you have to find out. Now, my lords, I had already shown to further buttress this issue only. My lords would recall I was referring to the fact that I had in fact filed within the same registration, my lords, separate application for vote and separate for the SEZ. That, my lords, would only, my lord, notice. I have pleaded it also, I have attached it also, and they have not disputed it. Annexure 2.
Para 33, if you're written.
That's right, my lords. Right. My lord, all those applications I have attached at Annexure 3. And, my lord, they don't deny it. In fact, they admit it. My lord, that separate refund also they have noted.
Page 10 of the counter.
So, my lords, point, my lords, why? They themselves is doing it. It's not as if it's something alien in the act or their system that I am saying that please bifurcate it. They are themselves doing it. And I have, for that purpose, very purpose, my lords, I demonstrated what 4 says, excluding 4A and 4B.
Right.
My lords, I just for a moment, my lords, may have it again. It has some relevance with this, my lords. I was referring, my lords, to Rule 89.4, which my lords would find at page 9 of my provision compilation, my lords. Relevant part, my lords, which I wish to show, my lords would find 11 and 12. So, my lord, they are themselves saying SEZ separate application for same registration, export separate. Now, my lord, would see further. My lords, when they compute in 4, my lord sees formula is by multiplying it by net ITC, my lords. And net ITC, how it is defined, my lords? Net ITC means ITC on inputs and input services during the relevant period, other than ITC availed for which refund is claimed under 4A or 4B. So, my lord, further bifurcation within the same unit, they are themselves doing in the rules. And what they say in 4A and 4B, my lords, they say, please find out what is the credit in respect of inputs or input services used in making the goods or services which are exported or SEZ. So, my lord, they themselves are saying, please find out what is those which relate to exports. Please find out. And what would be that, my lords? In Gujarat, my lords, they themselves, in a similar matter, filed an affidavit. They themselves filed, my lords, in a case titled as Messrs. Philatex India.
Even before Gujarat,
ये तो मेरा है. Yeah. Lord, there the assessee was arguing, please allow me to go by 4. What the commissioner stated was that, my lord would find that particular affidavit of the commissioner, my lord would find at para 27. Mr. Dave vehemently submitted para 27, my lords.
Yes.
Yes, my lord. Mr. Dave vehemently submitted that, in fact, if there is any formula which could be said to have been provided for purpose of adjudicating the claim, the same is to be found in 89.4 as Subrule 89.4b does not provide for any formula. However, Mr. Dave invited the attention of this court to the stance of commissioner as reflected in affidavit in reply filed on behalf of respondents. We take notice of the fact that Shri Manoj Kumar Srivastav, Principal Commissioner, affirmed the reply stating as under. The petitioner's contention that they are unable to establish the quantum of ITC availed in respect of inputs or input services to the extent used, not the extent used in 4A and 4B, to the extent used in making export of goods, is absolutely non-tenable, illogical, and far from factual position. Every manufacturing process have clearly specified ratios of inputs, raw materials to be used, which are to be strictly adhered to for production of finished goods. Therefore, each and every manufacturer must be aware of input-output ratio of the inputs or raw materials used in such manufacturing of the exported goods and ITC availed against such input supplies received. Otherwise, they cannot arrive at costing of finished goods. Accordingly, contrary to petitioner's contention, the required information can be easily bifurcated along with quantity. That's what I am asking. I am asking you take my input-output ratio, take unit-wise accounts. Further, the claimant must be aware of turnover exported good, the input-output ratio, that is exact quantity of raw material input supply used in such export, and ought have capacity to bifurcate ITC available used in such export, and hence the claimant's contention they cannot identify the input supplies used in exports exclusively as input supplies are common in both exports and DTA is not tenable and also not sustainable. Thus, emphasizing that they are unable to follow the procedure as prescribed under 89(4)(b) is not possible to them is totally baseless and not acceptable. Then, my lords, what my lords have held that.
It should go back. Para 32.
Yes, my lords. Para 32.
And apply that.
But keeping in mind the formula of input-output. That's what, my lords, I am submitting. My lords, it is their consistent stand. That is what the rule says. That is what their intention says. That is what their affidavit says.
All right.
Now, my lords, procedure cannot take away vested right, my lords. I have mentioned that in my note. I need not show, my lords, that. I have... then, my lord, the rule cannot go beyond the section, my lord. That I have, my lord, argued. I need not, my lords, bother my lords. My lords, I have referred to those paragraphs. Now, my lord, the last contention is Circular 125, my lords may kindly see. That, my lords, would find in the, my lords, annexure. Para 8 and para 2 of the circular, my lords.
Page 40 it begins. Yeah, 43. Relevant portion of the
40. My lords, this is annexure 4.
That's right. Page 43, I think. It's there.
Lord, what para 2 says is the necessary. Milords are having circular 125?
Yeah, page 40.
Milords, page. I'm so sorry, Milords. 40.
This is compilation.
Compilation. I'm sorry, Milords. I was reading from file. Yes, 40. Yes, my lord. The necessary capabilities for making the refund procedure fully electronic, in which all steps of submission and processing shall be undertaken electronically, have been deployed on common portal with effect from 26/9/2019. Accordingly, the circulars issued earlier, laying down the guidelines for manual submission and processing of refund claims need to be suitably modified, and a fresh set of guidelines need to be issued for electronic submission and processing of refund claims. With this objective, and in order to ensure uniformity in implementation of provisional law, the board, in exercise of its powers conferred by section 168, hereby lays down the procedure for electronic submission and processing of refund application in supersession of so and so circulars. Next page, Millard.
Following modalities.
That's right, Millard. So, Millard, by this circular, they have made it mandatory to file electronically. On this basis, Millard, he says you have not filed electronically, whereas I was unable to file electronically. Why, Millard? That Millard would find at para 8.
So, the period for which refund claim has been filed cannot be spread across.
Yes, Millard. This was, Millard, stayed by the Honorable Delhi High Court. This para, Millard, para 8. This para, Millard. Then, Millard, the council accepted that yes, there is no restriction under the section 16 that you can't go beyond a financial year for filing the claim. Delhi High Court says, how can you add these frivolous kind of conditions? A person is having opening credit prior to the period which he selects. So, Millard, what happened in that case? The purchases were made in one financial year. He kept on making the stock. Another financial year, exported everything. Now, Millard, in first year, he can't claim because there is no export. In the next year, he can't claim because there is no purchase. And in both the years, he can't club because the circular says you can't club. Likewise, here, Millard, the same para 8 also says, last 5 lines, Millard, this means that an applicant, after submitting a refund application under any of these categories for a certain period, shall not be subsequently allowed to file a refund claim under the same category for any previous period. So, Millard, if I have filed a claim once during a period, then if I have left some claim to be further taken, he says, despite it being within 2 years, you can't claim it. Millard, this has no rationale. And Millard, the para 2 has been quashed or read down or set aside or considered to be inoperative in light of 97A rule. Millard, may kindly see 97A. By at least 2 High Court division benches, Millard.
Is there the same compilation you set it out?
Millard, the judgment?
No, 97A.
97A, I have not, I think. Millard.
Page 29. Page 29.
97A is there, Millard. 29 page.
Correct.
Notwithstanding anything contained in respect of any process, procedure prescribed, any reference to electronic filing of an application, intimation, reply, declaration, statement, electronic issuance of notice, order, or certificate on common portal shall in respect of process, procedure, include manual filing of said application, intimation, reply, etc. Manual. This Milords, while sitting Milords in division bench in Delhi, had Milords order on several occasions. Milord, in the compilation, those two orders are at 15 and 16. Otherwise, this circular has been held to be wrong, bad by Allahabad High Court, Milord, serial number 14.
Right.
And one more latest judgment of Bombay High Court, Milord, I will hand it over just in a minute, Milord. I have that also. And Milord, for para 8, what the Honorable Delhi High Court had held, Milord, that Milord would find at serial number 9. Milord, that would make slightly interesting reading, Milords. The Milords had examined that scheme of exports in that, Milords, para 12 at page 86. Milords, around 12 lines from top says the entire concept of refund of ITC relating to zero-rated supply would be obliterated in case the respondents are permitted to put any limitation and condition that takes away right to claim refund of all the taxes paid on domestic purchases used for purpose of zero-rated supplies. The incentive given to export would lose its meaning, and this would cause grave hardship who are earning valuable foreign exchange for the country. The respondents cannot artificially, by acting contrary to fundamental spirit and object of the law, contrive ways to deny the benefit which the substantive provisional law confer on the taxpayer. And my lord, ultimately, Milords, their lordships, Milord, in para 13 had stayed the circular.
So what happened finally?
Thereafter, Milord, the government itself accepted. That is noted in the impugned order itself. Oh. They had changed that para, but only to the first part, since this honorable court interfered on first part. Milord, they corrected the first one, but left the second part to be there, that I can't find second application. These are all the grounds on which, Milords, my applications have been denied. Ultimately, Milord, there is no dispute on facts.
Right.
And this, if this is so read, Milord, it will deny me the benefit which is available to me. And this will become cost. I become uncompetitive, Milords, in the international market. This is the long and short, Milords, of the matter.
Right.
And Milords, I have already submitted that I am not claiming exemption. It's zero rating. So, Milord, the principles of exemption will not at all apply in this case. Rather, the contrary will apply. It is in public policy to grant the benefit, and the intent is also clear.
Right.
वो बॉम्बे वाला भी दे दीजिए. But the Allahabad judgment is in the compilation. This is the Bombay judgment. Saying the same thing, Milord. Nothing. It is just saying the same thing, Milord. Just for completeness, Milord, right. Since it is a division bench. Regarding para 2.
Correct. All right.
Deeply obliged, Milord.
So, Mr. Chimanka, when will you reply? You have to unmute. You have to unmute.
Petitioner advocate, you yourself have discussed the entire counter affidavit of mine. That's about the 3 points. That the registration matter and the refund matter and the consolidation matter. That has been discussed in the counter affidavit. That has been discussed by Lordship.
All right. Then we reserve orders.
Deeply obliged.
All right.
I'm grateful.
All right. All right. Correct. Correct. That's a good note. Yeah. All right.
Obliged.
We have a weekly list. No, we have a weekly list.
Oh, I'm grateful.
All right.
Weekly list for hearing. Item number 2.
Yes, my lord, the question of frame has been lost at page 12. Substantial question of law. As to whether in the present facts and circumstances, it is just and proper and legal on the fact of the learned CSAT to reverse the order passed by the Commissioner Appeal to the extent of demand of duty on ship store. There is a ship store of Indian origin. Second, as to whether it is just and proper, legal on the fact that the learned CSAT without Section 20, read with Section 12 of the Act, is its proper prospective reverse the order passed by the Commissioner Appeal to the extent of demand of duty on ship store on Indian origin. Then as to whether in the present facts and circumstances, the benefit of notification number 9496 custom dated 16/12/1996 can be extended to the respondent. This is very important. And last, as to whether the present facts and circumstances the imported store retention of board regulation 63 is applicable to the present case. My lord, I have quoted the
No, where is the respondent here? Mr. Vivek Mohanty. So it's only to the extent of ship stores.
Yes, yes, my lord.
Of Indian origin.
Yes, yes. And that I quoted the entire imported store retention of boards regulation at page 9. And my grounds appeal is page 8, 7, 8, 9. Page 5, grounds of appeal. That the challenge the appeal of complete illegal, arbitrary, misconceived, contrary to settled principle of law, hence the same is liable to set aside. Charging section 12 is very important, except as otherwise provided in this act or in the law for the time being in force. Duties of customs shall be levied on such rates as may be specified under the Custom Tax Act 75 or any other law for that time being in force on goods imported into and exported from India. Section 223. Then ground number C. For the instance case as claimed by the respondent, certain quantity of oil was stored in the vessel when it was under coastal run on 1997 when the said vessel was converted to foreign run. The quantity of Indian origin oil left in the vessel unused would be treated as good.
You're there for the respondent.
Lordship. Lordship, kindly adjourn it next week, her daughter marriage, Lordship.
All right. It will stay on board then. All right.
Lordship.
The respondent wants an adjournment, Mr. Chimanka.
Yes, yes, my lord.
All right. Stay on board. All right.
Item number 3.
Your Lordship, item number 3, Your Lordship may kindly turn to page 15, the question of law. Whether in the facts and in the circumstance of the case, in absence of notification of central government in consultation with the board as required under section 3V4, read with section 3AA, and section 5 of the Drugs and Cosmetic Act 1940, the commodities parallels CST tubes, VST tubes, one-touch test tips, vial packaged and lancet do not fall within the scope of entry 54 of the scheduled goods, subject to levy of sales tax under the Orissa Sales Tax Act. Your Lordship, the same question of law and whether it is coming drugs or not, Your Lordship. Now, Your Lordship, may kindly entry 54, Your Lordship, I have quoted at page 6 of the revision petition. Page 6, Your Lordship, entry 54. Entry 54 says, from 1/4/2001, it is taxable list, 8%. Drugs is defined in clause B of section 3 of the Drugs and Cosmetics Act 1940. Ayurvedic, homeopathic, Unani medicine other than ginger, tincture, and those exempted under section 6 of the Odisha Sales Tax Act 1947. What are exempted? That is life-saving drug, quinine, so on, so on, so on. Now, Your Lordship, what the Lorraine Tribunal has done, Lorraine Tribunal has treated, Your Lordship may kindly turn to page 34, the Lorraine Tribunal's order, Your Lordship.
Here, I think again, who's for the respondent here? That AD card is not.
Causeley says that AD of hearing notice not yet done.
What's the tax effect here?
Tax effect is, Your Lordship, 1,07,283.
Dealer has already paid 2,18,000. And leave the question open, sir. Leave the question open.
Yes.
The tax effect works out to. You say the tax effect is not substantial to require interference with the court, particularly since in the last 8 years, the respondent has not even been served. Consequently, leaving the question of law open for decision in someone the appropriate case, the revision petition is disposed of.
Obliged.
Weekly list item number 4.
I'm appearing in this particular case. Also, Miller, I'm extremely sorry, Miller, the adjudication order and the order in appeal has not been enclosed.
Oh.
May I be permitted to just file it? Also giving a copy to my learned friend.
On the same similar issue, Milord, the
Similar
High Court of Bombay has decided in favor of the accession law.
Okay.
Against that, the department has preferred a SLP which is pending, still pending for adjudication.
Oh, is there a stay?
On the same issue.
No, is there a stay?
No, there's no stay.
No stay. No stay.
The entire
Why
issue.
don't you follow the Bombay High Court and this will also go taken there?
No, it's the entire issue is, my lord, whether the Port Trust Act, my lord, protection under the Port Trust Act, my lord, especially section 42 and 43, my lords, would have an overriding effect or give some protection to the Port Trust authorities to become custodian of goods and not to be levied any penalty or duty, my lord, under 45(3) of the Customs Act, my lord. And there's another question that whether remission of duty is possible because these are not pilfered goods but lost in supercyclone, my lord, and whether section 23 of the Customs Act would be applicable, my lord. These are broadly two questions. And if your lordship would see the Bombay High Court, my lord, for the moment, my lords, I just pass on the order of the Bombay High Court, my lords.
Yes.
Yeah. Please. So the Bombay High Court was dealing with the question. The Bombay High Court was dealing with the question is the Port Trust liable to pay duty on goods pilfered while in their possession? Lords? Here, my lord, unfortunately, these goods are not pilfered. At the highest, my lord, if your lordship would take it to be pilfered goods also, then, my lord, they say that the Customs Act will not be making it liable for payment of customs duty, my lords. Then your lordship would kindly come to, my lord, straight away to page 3, my lords. Paragraph 9, my lords. May I just place 3 or 4 paragraphs, my lords? We have heard the learned counsel for the parties. First, let examine the scheme of the Act in the matter of payment of duty. Section 12 of the Customs Act is a charging section. Under Section 13, if any imported goods are pilfered after the unloading thereof and before the proper officer has made an order for clearance for home consumption or deposited in a warehouse, the importer shall not be liable to pay the duty leviable on such goods, except where such goods are restored to the importer after pilferage. In other words, the imported goods pilfered in the circumstances set out above are not liable for payment by the importer. Section 23 of the Customs Act confers power on the authorities set out therein to remit customs duty on goods which have been lost or destroyed at any time before clearance of for home consumption or otherwise as a result of pilferage. It is therefore clear that the duty under Section 12 of the Customs Act is leviable on the goods. Customs duty is payable by an importer considering Section 17 of the Customs Act. Only in the situation covered under Section 13 of the Customs Act, customs duty is not payable, and in the situation covered under Section 23, there is a power to remit the duty. Under Section 45(3) of the Customs Act, insofar as the goods are concerned, here, my lord, the entire demand is basing on Section 45(3) of the Customs Act, my lords.
And that they say can't cover a port.
My lords. And they have taken into consideration the Major Port Trust Act, my lords, and especially Section 43 of the Port Trust Act, my lord. And they have delineated, my lord, the provisions of the Port Trust Act, my lord, that's at page 2, my lords. 42. And the responsibility of the board for losses, and 45, my lords. Briefly, my lord, I'll just take your lordships, my lord, to the facts of this case, my lord. Here, Mesco, my lord, had imported lamb coke, my lord, from China, and it was unloaded in part of the Port Trust, which is admittedly declared as a customs port, my lords. It was stored in the warehouse, my lord. 8 numbers of, my lord, bills of entries were raised and goods were lifted, my lords. About 3,000 metric tons of goods were left, my lord, in the yard, which were not lifted, my lords. Then, my lord, 28th, 29th of October 1999, my lord, was the super cyclone, my lords. And the specific case of Mesco, my lord, was that these goods were not recoverable because they were lost in the super cyclone, my lords. This was intimated also to the customs authorities, my lords. Then, my lords, they take a stand that after this particular goods or the super cyclone, there were 4 bills of entry which were raised by Mesco, my lord, cleared by the customs authorities, and only 2 bills of entries, my lord, goods were lifted, and thereby 1,000 some odd metric tons of goods which were covering another 2 bill of entries, my lord, were never lifted, my lord. And the specific case of both Paradip Port Trust as well as Mesco, my lord, was that those goods were not recoverable because of the super cyclone, my lords. So my humble contention was Bombay High Court was at a much higher level of pilfered goods. And 45(3), my lord, if your lordship would kindly take up the Customs Act, my lords. Sorry. You've got it, 45 minutes. 45 says about restrictions on customs, on tea and removal of imported goods. 45(3), my lords. Notwithstanding anything contained in any law for the time being in force, if any goods are pilfered, my lords, after unloading thereof in a customs area, while in the custody of a person referred to in subsection 1, that person shall be liable to pay duty on such goods at the rate prevailing on the date of delivery of an arrival manifest or import manifest, or as the case may be, an import report to the proper officer under Section 30 for arrival of the conveyance in which the said goods were carried. So they, my lord, the entire case of the department, my lords, is 45(3), my lords. They say that since Mesco had raised the bill of entries, 4 bills for 3,000 metric tons, lifted, my lord, about 2,000 some odd, leaving a balance of 1,000 metric tons of goods, my lords. And since bills of entries were raised, these goods, my lord, are dutiable goods and you are liable to pay. That is the entire case of the department, my lords. So I took a stand before the authority, my lord, if you should take up that particular paragraph, my lord. That's why I've given your lordships the orders of the authorities below, my lords. Now, all these, my lord, happened in the year, my lord, 2000, my lords, 99-2000. They slept over for 3 years, my lords. And Paradip Port Trust, in the year 2003, January, my lord, they were given a show cause, my lords. And that, my lord, would be apparent, my lord, if your lordship would kindly take the adjudication order, my lords, at page 12, my lords.
Yes.
The paragraph will be at the footnote, my lords. Page number, my lords.
Yes.
Paragraph 4, my lord. that even assuming not conceding for the sake of argument, Lordship Court.
Para 12, right?
Para 4, my lords.
4.
4, my lords.
Sorry.
At page, internal page number 12, my lords.
Right.
Even assuming not conceding for the sake of argument that the port is a person in custody of these imported goods within the customs. This is a part of my submission, my lords. Because within the customs bonded area by the operation of or notification issued by the customs, and that the port as a custodian is liable if any imported goods are pilfered by the customs bonded area for their own custody. Further, they stated that in the instant case, there's no basis to come to the conclusion that the goods have been pilfered. On the contrary, the importer Mesco, in the letter dated 1/4/2000, has intimated the customs authority that the entire quantity of imported goods, that is 1,001.5 metric tons, have been washed away in the super cyclone, which occurred on 28/9/1999, 29/10/1999, and the same are not retrievable. Mesco, the importer, has also stated that the goods are not in existence and question of assessment and discharging of duty of liability does not arise. This letter was sent to the customs authorities on 1/4/2000 as apparent from the show cause notice. Thereafter, no action was taken by the customs authorities till 18/7/2003 for a period of more than 3 years. In view of the matter, the allegation made by the customs authorities in its show cause notice, that goods have been pilfered from the court premises. Now, they interpret the loss of goods due to super cyclone as pilfered goods, my lords. And as the basis is purely an afterthought. Then, my lords, they say, then I have also taken the stand of remission of duty at paragraph 6, my lords. Ultimately, my lord, they come to hold your findings, my lord, at page 18, my lords. At page 19, my lords. The findings of the adjudicating authority, my lords. Lordship Court. PPT in their reply have stated that as per the terms and conditions of the license granted to Mesco for allotment of stockyard inside the port premises, they are not responsible for any pilferage, theft, damage, and loss of any cargo. And also, as per section 42 and 43 of the Major Port Trust Act 1963, PPT does not act as a bailee for the bulk cargo. In this regard, it is stated by Mesco that when the bulk cargo was in the custody of the port authority, it had got no access to clear the cargo unless and otherwise due delivery is granted by the port authority after due verification of the stock position lying in that site. As evident from the above discussion, above and the write-ups submitted, there is a non-payment of customs duty to the tune of 17,41,843 only on the remaining 1,001.5 metric ton of lamb coke assessed by bill of entry number so and so, and the show cause notice has been rightly issued importer as per section 3 of section 45 of the customs duty. The custodian PPT Paradip, having failed to account for 1,001 metric tons of lamb coke in respect of which Mrs. Mesco has filed the bill of entry number so and so, have made themselves liable to pay customs duty in respect of the above cargo. In absence of any information from PPT Paradip regarding loss or destruction of the said 1,001.5 metric tons of lamb coke by natural calamities, etc., and in view of Mrs. PPT belatedly asking Mrs. Mesco to account for this cargo, it appears that the said goods have been pilfered from the port premises after discharge from the vessel. It has been questionably contended by Mrs. PPT without any reasonable supporting documents of evidentiary value that the goods have not been pilfered in the customs bonded area. B, the port was not in charge or custody of the goods in question. C, the goods have been lost due to natural events like super cyclone on which the port has no control, and therefore the documents relied upon by Mrs. PPT fails to explain the disappearance of the said 1001.5 metric tons of lamb coke and why section 45(3) of the Customs Act would have no application in the instant case. Therefore, I am of the view that PPT are required to pay customs duty under subsection 3 of section 45 for contravention of subsection 1 and 2 of the said section, read with section 48, amounting to rupees so and so, and they levy an equal amount of penalty, and that's how, my lord, this order has been passed, my lord. Before the appellate authority, my lord, she gives us very strange finding, my lords. If your lordship would kindly turn to, my lords, page 2 of the appellate order in appeal, my lords, paragraph 6. I find that PPT, your lordship got it? Yes. I find that PPT has been inter alia declared as a customs port in terms of clause A of section 7 of the Customs Act 62 under notification of a so and so as amended for unloading of imported goods. Mrs. PPT has been authorized and appointed as custodian, and all imported goods unloaded in the port remains their custody till they are clear for home consumption or are warehoused or transshipped as provided in the law. The PPT, being the custodian, after taking over the imported goods from the carrier, arrange its proper storage and safety and allow clearance to the importers only after they fulfill all the customs formalities, pay off requisite duties and other charges and fee, and discharge various other obligations before their goods are allowed entry into the country. And the customs have given permission for clearance out of customs area. The custodian is required to execute a bond equally to the average duty involved in the goods likely to be stored. Till physical clearance is taken by the importer, the goods remain under the custody of the port trust authorities, and therefore the importer may not have any control over the said goods. The appellants have stated that in view of the provisions enumerated in section 42 and 43 of the Major Port Trust Act 1963, and as per the condition of the license granted to Messrs. Mesco, by them, the goods stored in open spaces, stockyards, sheds, and other places shall remain at the risk of Messrs. Mesco, and therefore they are not responsible for any pilferage. The appellants had otherwise admitted about the pilferage. I said, my lord, that I am not responsible if the goods are pilfered. Now she takes it as if there's an admission on the part of the appellants that admittedly there has been a pilferage, and they claimed that for such pilferage, Mrs. Mesco was responsible. No, that is completely a wrong finding, my lord. And the tribunal, my lord, they concurred with the findings without, my lord, considering 42 and 43, my lords, of the Major Port Trust Act, my lords. So that's why I rely on this judgment of the Bombay High Court, my lords, where they say, my lord, this 40
pilferage, you're not glad.
My lords. At the highest, my lord. So my case is it's a loss due to natural calamity, my lords.
Lordship, kindly turn to the adjudication order, first paragraph.
Finding this.
Because Mesco is not replying, you went after people. That's what the first paragraph says.
That's exactly the case. Mesco, in fact, they fled away.
That's the point.
And 3 years thereafter, my lord, when they could not catch hold of Mesco. And this is common knowledge about the destruction of in the 99 super cyclone, my lord, especially the Paradip area, my lord, is well known to them. It's well known to the customs authorities. The entire office was destroyed also. But still they say it's pilfered, my lords. Including the office.
The finding person, my lord. Page 18, my lord. First paragraph. Page 18.
Yes.
I've gone through the case record and submission made by Messrs. PPT Paradip and the Mesco Steels, the importer, thoroughly. It is a fact that Mesco Steel imported 28,502 metric tons of lamb coke during the month of June 1999 per vessel such and such through Paradip Port. The unloading of the lamb coke was completed on 27/6/1999 and the same was kept in the open stock at number such and such of Paradip Port meant for MESCO. Messrs. MESCO cleared 25,500.6 metric ton of lamb coke from Paradip Port under 8 bills entry. On 9/12/99, MESCO requested the Assistant Commissioner of Customs Paradip to extend the time under Section 48 of the Customs Act to file bill of entry for balance cargo of 3,001.5 metric ton. The delay in filing the bill of entry was waived under Section 48 after considering the reason given by the importer. My lord, kindly mark, it is on 9/12/99. It is MESCO has filed on 9/12/99.
You woke up after 3 years.
My lord, on 9/12/99, but the super cyclone has happened on October 99. After 2 months, MESCO is filing a extension for filing of the bill of entry for those people.
Restoration took so many months.
And your lordship would appreciate Section 48 mandates that this goods, if not cleared within 30 days, have to be put to auction, my lord, by the custodian. They kept on merrily giving time to MESCO, my lords, extending their time for lifting. Section 48, if your lordship see, Lord, it gives a time limit of 30 days, not for lifting of the cargo, otherwise it will be put to auction. They merrily granted time to MESCO. I'm sorry. They merely granted time to MESCO for lifting of the goods. When MESCO failed and they said that 1,000 some odd, but sorry.
That's it.
So many months and that took Paradip.
Well, the questions have been framed, but may not be very happily worded, my lord. At page 16, the lordship would see. No, my lord. Admit, my lord. No questions of law have been framed.
One question is enough.
My lord, one question is enough. That is question number 6. It's not very happily worded, though, my lord. So your lordship may pardon me for that. Your lordship may only add, my lord, that whether 45(3) of the Customs Act can be attracted in view of Section 42 and 43 of the Major Port Trusts Act 1963, my lords. Subject to your lordship's kind consideration, Lord, your lordship.
That is
And, sorry, my lords?
That's the Bombay.
That's the Bombay High Court.
Pending before the Honorable Supreme Court.
I know, you got that all.
My lord.
And there's no stay, my lords. And if your lordship may kindly consider about remission of duty, if your lordship answers this first question in my favor, remission does not turn.
We formulate that question a lot of following on.
Obliged, my lords.
Your lordship, next item, my lordship.
Your lordship, item number 9. Your lordship, I'm a counsel traveling out from. My lord, next item number 9 on in January. Your lordship will please.